Yeah, I have not seen yet.
Yes,
Again, those applications not appearing.
not appearing.
Several
Why
occasions
it is not appearing?
I served notice on the other side. I give the numbers. Several occasions. I think
কেন রিকুইজিশন করেছেন? হ্যাঁ, উনি তো আগের সপ্তাহে বলছেন, আগের সপ্তাহে মুভ করেছেন। তা আসছে না কেন দেখবেন, রিকুইজিশন পেটে হয়ে গেল। গত সপ্তাহে দুবার ধরে মুভ করছেন, গত সপ্তাহে মেনশন করেছেন, তার আগে
let the department be informed also. I don't know whether requisition is.
I am calling the department person.
And I am mentioning item number 8. It is assigned manual today. If your loss is fixed any day tomorrow or day after tomorrow.
Item number 8.
8. It is assigned to your losses.
Today's list.
Today's list.
You are for the petitioner.
I am for the petition. Yes, there is a caveat also. There are other side.
Have you served?
Yes, I have served. Let it be on tomorrow or day after tomorrow.
Let it appear in the list. Let me call it. Okay. Yes.
One second appeal matter, my lord. That is appealing. That is your lordship is taking every Friday, my lord. Appealing as item number 125, my lord. And this is not today's list, my lord. This is the list dated 21st February. And my lord, I am the decree holder, appellate decree holder, my lord.
Yes.
And this is the second appeal, my lord, because I am suffering, my lord. My execution proceeding is being stayed. And my lord, if this appeal is not being heard, the appellate decree
Appeal for the year
2014, my lord. And
2014.
yes,
I have long pending appeals.
my lord,
There are some preferences.
my lord, this is a real estate matter.
64 appeals, 71 appeals are pending. How
Lord,
can I take up these matters?
my lord, this is appearing.
That's why I have
If this can be-
passed an order.
Yes.
Before 2010, I shall not take any hearing matters. If the applications is there, I will take up.
Lord, the paper,
All matters have to be given
paperwork
preference.
has already been filed.
I know. But you know, more than my years, the appeals are pending before this court.
But
These are, there are some preferences
but my
in
lord,
the old appeals.
there is a continuous, my lord,
I know.
my lord.
You just wait for a month, thereafter I will listen.
My lord, I am playing for that appeal also, and this is 2010, ma'am.
2010 appeal. Who are you? You are for the
I am for the petition. Appellant. Appellant.
appellant. What is the status of the appeal? Paper books ready?
Yes. The public has
Who is for the respondent? Have you served? You serve. You serve, and thereafter you come.
My lord, upon notice, I am mentioning, my lord, Group 8 matter, application, my lord. My lord.
Lord, may I be permitted to mention an application for restoration allowing section 5. The appeal of 2000.
Under application.
Our second appeal of 1973. My lord, since none appeared, my lord, there was a direction.
You are for the appellant.
I am for the appellant. Since none appeared for the respondent, there was a direction for paper publication. I have done that. But my lord, after that, the one of the appellant has died. I have made the application for substitution. Let the application
Under the heading application. Friday.
Thank you.
Okay, call the matter. Yes. So, affidavit in opposition. Who is appearing for the state authority? You have. Do you have the report at least? Okay. Have you got the affidavit in opposition copy? So, whether we can proceed today?
Yes.
Very.
The Lordship kindly take up the review application. But one point I
No,
just want
review application.
to consider with that, the point, my lord, on last Friday, which has been strongly relied upon by the order of justice, petition may be presided over by Justice HON'BLE Bagchi. So that has been clarified on Friday. The order which was there, interim order was there, that is only binding to the parties.
Now, today we are now on final matter,
No, we are in the review application.
review application. Okay. Give me the review.
But the order has not come into the, my lord, the
Server.
server. But actually, my lord, whatever your lordship has held it, that is in the my writ petition, that is the observation, and that is the view has been taken by the
Yes.
with the review application.
Review application.
Now, kindly turn to this my review application.
Yes.
Kindly turn to page 21.
Page 21.
But before going through the order, my lord, a vacancy notice has been notified on 1st September 2022 for appointment of MR distributor at Raiganj block, Uttar Dinajpur, was under challenge before the court.
Yes.
In that writ petition, an order has been passed by Justice Joyshing Gupta on 19th of January 2023, page 21.
Yes.
It is Sujata Mitra versus State. I am reading the order. Affidavit of service filed on behalf of the petitioner is taken on record. And all the parties are represented. Who are the parties? Kindly see the Advocate General, because files of the act was under challenge. So we have served the Advocate General, they represented, state represented, and petitioner also represented. All the parties are represented. Are the learned counsel for the parties. Or kindly take note of the next paragraph. It is pointed out on behalf of the learned counsel for the parties, not all the parties pointed out before the court, that the same issue is being deliberated upon by a division bench of this court in MAT 296 of 2022. Well, kindly take note of this 296 of 2022.
Yes.
This is in respect of my lord Shakuntala Devi Kataruka. Kindly take note of this name, Shakuntala Devi Kataruka.
Yes.
Shakuntala Devi Kataruka preferred an appeal that was mentioned by all the parties. The next date in the case has been fixed in the month of February 2023. Let the matter come up for hearing in the list under the hearing for order in the first week of March 2023. Now, my lord, submission has been recorded, first paragraph, rather third paragraph, then the parties shall be at liberty to file written notes of argument on the next day. In view of the point taken by the petitioner, my lord, kindly take note of. In view of the point taken by the petitioner in that writ petition, that under the central control order of 2015, there is no provision for distributor. Let the respondent not finally appoint any candidate in respect of the vacancy notification in question. However, they shall be entitled to otherwise proceed with the selection process, urgent photostat process. So, my lord, your lordship knows in every order or judgment, there are three parts.
Yes.
One is the submission of the councils, next the observation findings of the court, then the order in portion. In this case, all the parties pointed out before the court that the issue involved in the writ petition is also issued in respect of an appeal. Then observation is that since the writ petitioner in the writ petition took a point that under 2015 central control order there is no provision for distributor, court squared with the same, passed an interim order until further order. The order is not till disposal of that appeal. In some cases, court passes order, interim order till disposal of the pending appeal where the issue also involved.
Yes,
In this case, order has been passed till disposal of the writ petition only on recording that issue involved in the writ petition are also one of the issue in the division bench. Now, your lordship, kindly turn to the page. The order passed by your lordship in the writ petition filed by my learned senior friend. That is Sujan Chandra Rai, page 23.
yes,
But this is an order of 30th January 2025. The court is moved in the original side matter. The instant writ petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner in respect of the vacancy distributor at Block Raiganj under Division Raiganj in the district of Dinajpur. Matlab the vacancy which was under challenge before Justice Joyson Gupta, that vacancy they paid for an order. It is a case of the petitioner that the Deputy Director License, Directorate of District Distribution, Procurement, Supply, has issued a memo on 8 June 2023. Kindly take note of 8 June of 2023. This date is subsequent to the dismissal of the appeal. I shall show to your lordship.
yes,
Containing entirely, but this memo has been issued by the Deputy Director addressing to the district controller of the concerned district, that is my lord Uttar Dinajpur. Memo dated so 8 June 2023. In connection with the Food and Supplies Department number under reference on the caption subject, the undersigned is directed to inform him that after the consideration of as per central control order, application for distributorship license of Sujan Chandra Rai, that is the petitioner, has been approved by the Food and Supplies Department, Government of West Bengal, for engagement of IMART distributor against fresh vacancy at Raiganj Block, District Uttar Dinajpur, published by memo dated 1st September 2022, which was under challenge before the court. I have shown to your lordship in the official gazette as well. So the next paragraph is very important. But in view of the interim order of the Honorable High Court, this is the order passed by Justice Joyson. In the matter of WPA number 1151/2023, Sujata Mitra versus State of West Bengal and other, license in favor of your approval, appointment shall be made. Respondent, appointment should not be made, shall not be issued till disposal of the writ petition. Kindly take note of. So government realize the position and observe what is the order passed by Justice Joyson Gupta.
yes,
Honorable Justice Joyson Gupta passed an order, interim order till disposal of the writ petition.
yes,
So rightly, it has been recorded in the approval letter that unless the writ petition is disposed of, we are not able to pass grant any license, following the order of Justice Joyson Gupta. Then, my lord, next page. It is the case of the petitioner that an interim order was passed in WPA in view of pending of appeal, being evident that said appeal has been dismissed. But I object to this submission to the effect that the interim order has not passed by Justice Joyson Gupta till disposal of the appeal. Justice Sengupta passed an order independently on merit, definitely on prima facie, that since a point has been taken under Central Controller 2015, there is no distributor. I am passing an interim order till disposal of the writ petition. Mr. Swanson, learned senior advocate, appearing on behalf of the petitioner, submits there is no embargo to issue license in favor of the. There should be clear pronunciation. Clearly, that is clear.
yes, proceed.
To issue license in favor of the petitioner, as there is no such interim order for issuance of license in favor of the petitioner. I also object, my lord, interim order is still there. That interim order is still in force, writ petition is still in pending. Mr. Swanso also fairly submitted that virtue of decision of bench of petition passed in WP Swanso, an appeal being made Swanso was preferred before the Honorable Division Bench, wherein an interim order was passed by the Honorable Division Bench for not to delink any dealers from any distributor. That is correct, my lord. Mr. Swanso submits that the present petitioner is not a party to the proceeding, so the interim order passed by the Honorable Division Bench is not effective upon the petitioner. Mr. Sonal Sinha, learned counsel appearing for the state, respondent submits that the authority concerned has already taken a decision for issuance of license in favor of the petitioner, so necessary order may be passed. This I also objected to.
Yes,
The state has said in the approval letter, unless writ petition is disposed of, we cannot grant the license. Submission behalf of the state, they are ready to grant the license. I don't know what instruction was obtained by the state advocate, submitted before your lordship, that they are going to issue the license. It is contrary to the order passed by the authority not to grant license till disposal of the writ petition. Next paragraph. Having heard the learned counsel for the parties, it appears to me that the impugned memo dated 8 June 2023 specifically restrained the petitioner from issuance of a distributorship license by virtue of a pending interim order passed in WP number so and so. The interim order in WP number so and so was passed by virtue of a pending appeal prevailing remedy. The said appeal was dismissed and so and so. Well, your lordship has been persuaded as if the appeal order has been passed by Justice Sengupta. Till disposal of the appeal, there should be an interim order. Had there been proper assistance, we have been made party, we could have mentioned with your lordship what is the order passed by the division bench. I shall show to your lordship. Next paragraph. Thus, there is no legal impediment to issue license in favor of the petitioner. The petitioner is not a party to appeal number so and so. Thus, the interim order in appeal is not binding upon petitioner. Under the above observation, the instant petition is disposed of with the direction upon the concerned authority to issue license in favor of the present petitioner according to the provisions of law if it is otherwise found to be eligible. But this is contrary to the order of Justice Joyson Gupta. This is contrary to the order passed by the department at the time of granting approval. Now we favor a review application. Now your lordship kindly take up. I shall show before your lordship the judgment which has been delivered in Calcutta case. What happened in that case? Just brief facts of the case is there.
yes,
Well, just brief facts of the case for the Calcutta is concerned. A vacancy of MR distributor has been notified in Raghunathpur block, Purulia. Your lordship did not call because that is not there. But one company applied for against the said vacancy. The department rejected his application on the ground that company does not come within the purview of group of individuals.
that is
That-
WP 1151,
No. MAT, I shall show to you.
MAT, okay.
Shakutala Devi Karan, which has been referred to by Justice Joyson Gupta, which has also been brought notice to your lordship by my learned senator. Order of rejection by the department that your company does not come within the purview of group of individuals was under challenge in a writ petition.
Okay.
That writ petition was allowed, order has been quashed, direction has been given to proceed with the matter. One of the distributor of that area from whom dealers will be detached, Shakuntala Devi Kataruka, filed an appeal against that order with an application for leave to appeal because she was not party in the writ petition. Initially, that matter was taken up for hearing by the division bench, presided over by the present Chief Justice as a puisne judge, and interfere with the matter, allowed the leave to application and pass an interim order, not considering the 2013 control order other point. With the rider that all points left open at the time of final decision of the appeal. Now, your lordship kindly take up the judgment delivered by Justice Honorable Division Bench, decided over by Justice Stanford. I have last occasion handed over, I can hand over. Your lordship kindly take up this. This is the appeal. I have the privilege to appear and also my learned senior can appear in the for other side. Shakuntala Tataruka kindly similar the number MAT 296, which has been referring all out. I'm reading from first to paragraph. The instant appeals at the instance of the appellant being a third party to petition, being WPA number so and so, alleging that the order disposing of the said petition prejudicially affected the right of the right, and therefore she has satisfied the intelligence of a person aggrieved. But the matter which was initially considered by the present Chief Justice was finally taken up for hearing by the division bench, decided about Justice Danwood. Next paragraph. A leave to appeal was sought and the coordinate bench disposed of the said application on 8th of April 2022, granting leave to appeal with a rider that the grant of leave as restricted on the reason stated therein and shall not be constituted to have any impact on the merit of the matter, which would be considered when the appeal is under admission. Now, my lord, kindly come to page 4. From third paragraph. My submission has been recorded. On the other hand, Mr. So-and-so learned advocate appearing for the appellant submits that though the leave to appeal was granted on 8th April 2022 by the coordinate bench, but in a later order dated so-and-so, it is an express recording to the effect that such leave is tentative in nature and all points agitated in the instant appeal shall be decided at the time of final hearing, including the one which regard to the locus of the person aggrieved. He submits that clause so-and-so of the control dated so-and-so constitutes that the application cannot be made by a group of individuals who are not resident of the locality for which such applicant for MR distributorship is made, nor condition a group of individuals to be considered single eligible for the MR distributor. If there are holding of license in respect of any other area, he further submits that the respondent number 1 has a subsisting license of MR distributorship in other area and therefore she is not entitled to get the considered for MR distributor of Ratnathpur block in the district of Purulia as a last resort is so and so. This is the submission. Then finally turn to matter page 6 of the judgment. What was the consideration? Whether the merit has been considered or not, I shall place before your lordship. Page 6, last paragraph. We do not think that the ultimate decision taken in the interim order has foreclosed the right of the respondent number 1, nor the closed the door of the authorities in not considering the application on the basis of the confidential incorporated. In the said notification, the interim order neither bestowed any right as a successful candidate nor any imposition is made upon the authorities to decide the said issue by this way or that way. The order is innocuous to the extent that the authorities have to proceed with the application filed by the appellant number 1 and in the evidence that the authorities shall take into account all the conditions attached to the said notification and shall take on independent decision in this regard. Since no decision has yet been taken, the right of the appellant, that's my client, does not appear to have been infringed and therefore the plea of person aggrieved does not appear to be sound and logical at this stage. The concept of person aggrieved originated on a principle that if an order is passed in a proceedings between the litigants affecting the right of third party who is not included in the proceedings, such third party may assail the said order before the higher forum upon seeking leave to appeal. The brief of aggrieved has to be judged in the context of the decision taken by the original authority or the court of first instance on the basis of the cause of action pleaded therein and the tenant of the authority decision. Merely a proceeding is initiated and the ultimate decision does not affect the right as no final decision has been taken. As in the case, the appellant cannot be said to be person aggrieved to maintain in the appeal as person aggrieved. Then, very important. Since all the points were kept open, including the point of locus, and having him so that the appellant does not have a locus as a personal aggrieved, we do not venture to decide the other issue raised in the instant appeal. We have been given an understanding that several litigation are pending. That is the pending cases in regard to 2013 control order, whether it exists or not. In relation to distributor system within the state, West Bengal on various grounds, including the grounds which have been taken in the instant appeal. Therefore, it would be apposite to record that those points shall not be decided to have been decided by us in the instant appeal, impliedly or expressly. since our judgment is restricted to locus of the appellant to maintain the appeal as present a person agreed, therefore, all other issues are undecided and kept open, and if taken at any other proceedings, be it collateral or otherwise, shall not be constituted to have been impliedly decided by the instant appeal. So what happened, my lord? Only on the point of locus, appeal has been dismissed, keeping all points left open, including the point whether after coming into force, National Food Security Act 2013 and Central Control Act 2015, 2013 State Control Order has any existence or not, and invoking the provision of 2013 Control Order, whether any vacancy of MR dealer or MR distributor can be notified, that issue kept open by the Honorable Division.
Yes.
But a bunch of writ petition was moved. Some of the writ petitions were taken up for hearing by a coordinate bench. Not all, including the writ petition where Justice Joyashin Gupta passed an order that was not taken up for hearing. That is still pending, intimate is still there. Some writ petition was taken up for hearing and the writ petition ultimately dismissed. On 2nd of August 2024, that writ petition has been dismissed. Can you take note of? 3rd of August was the Saturday, 4th of August was the Sunday, 5th of August, I mentioned this matter before the division bench presided over Justice Joy Malla Bagchi. On 6th, an interim order has been passed by the Honorable Division Bench, restraining the respondents from delinking any ration cards from any dealer and delinking of ration cards from a dealer and delinking of dealers from distributors in respect of the appellant. I'm once again saying in respect of the appellant. Not judgment in rem, this is judgment in matter persona. Now you will also kindly take up the order passed in that appeal. I'm handing over a copy. Get a good sir. This is an order of 6th of August.
Yes.
Can you take note, page 2? First paragraph. Mr. So-and-so, the appellant contends, the state has taken pre-visiting stance with regard to full implementation of the National Food Security Act 2013 and are referred to as the National 2013. In the state, before the Honorable Supreme Court, the state had pleaded that the Act has been fully implemented. However, in the written submission placed before the Honorable Single Bench, the state stance of the second Act has not been fully implemented. Honorable Single Bench ought not to have been relied on such submission, which runs contrary to the state stance taken by the state in the special petition pending before the Honorable Apex Court. Mr. So-and-so with Mr. So-and-so, learned junior standing counsel, contend that the consistent stance of the state is that the Act has not been fully implemented. However, states are afford to implement the Act fully. In support of their submission, they refer to the observation in the impugned judgment that the Advocate General in a collateral proceedings had informed the court that the Act has not been implemented. Appellants are fair price shop owners and MR distributors under the West Bengal Public Distribution System Control Order 2013. The principal grievance is that issuance of vacancy notice under the state control order for appointment of new dealer under the state order. It's contended that the state control order 2013 no longer in force and it stands superseded by National Food Security Act 2013 and the control order 2015. Here apply referred to as the so-and-so. Provides to section 1 of the Targeted Public Distribution System Control Order 2015 entirely states Public Distribution System Control Order 2001 shall continue to have effect in the state which has not implemented National Food Security Act 2013 or is implementing the Act in part. Appellants have sought to make out a case that the state has taken inconsistent and evasive stance in the various postings with regard to full implementation of the National Food Security Act 2013. To clarify the position, we call upon the Principal Secretary, Food and Supplies Department, Government of West Bengal, to the affidavit disclosing whether the National Food Security Act 2013 has been fully implemented in the state or not, and if the same has not been done, the reason to its non-implementation in full. The affidavit shall be filed by 12th of August 2024. Reasons to the affidavit shall be filed by the so-and-so. Let the matter appear on so-and-so. We direct none of the ration card holders shall be dealing from the dealers, and the dealers shall not be dealing from the distributors if not already done for a period of 2 weeks from date on transfer. Not interim order has been extended time to time. This judgment, this interim order is only meant for the person who came before this court by way of filing appeal.
Yes.
This appeal is still pending. Now, what happened, my lord? Now, in some cases, so far order passed by Justice Joyson Gupta, that order has been passed. I am repeating, my lord, till disposal of the writ petition by recording the pendency of that. In some cases, some coordinate bench passed order that interim order till disposal of the appeal, that is Shakuntala, Katarika. In that case, after dismissal of the appeal, license has been granted. In one of that writ petition, an application has been filed before the court. And considering the division bench order and other aspects of the matter, your lordship passed an interim order in that case. This is where kindly take note of the name Kamalesh Chandra Fauzdar.
Yes.
What I am reading the order. This is an order of dated 27th of November 2024. This is an application for an interim order in respect of a stay at vacancy notification dated so and so, issued by the subdivisional controller of food and supplies, Bangarampur, Bunyadpara, PS, Bolshia, so and so, district of Mr. Bhattacharya, learned advocate appearing on behalf of the petitioner, submits that initially the time of filing of the instant writ petition, this court has passed an order of the disposal of an appeal pending before the so and so. Kindly take note of, my lord. Then that interim order was passed till disposal of the appeal, that is the Shakuntala Devi case. Mr. Bhattacharya further argued that similar issues are involved in both the appeals before the Honorable Division Bench, being MAT number so and so 24. The Honorable Division Bench has already passed an interim order. This 1543 is the Shitara Begum case. Subsequent appeal submits that the instant matter cannot be disposed of till the disposal of the appeal. So he prayed for necessary interim order. Mr. Amitlal Chatterjee, learned advocate appearing on behalf of the respondent authority, submits that this is a very old matter. The issue involved in the writ petition is not similar to that of issuance of pending before the Honorable Division Bench in the appeal. Hard Learned Council, the Hard Learned Council, the present petitioner challenged the improved vacancy notification for appointment of FIR shop dealer over the operation area where the present petitioner is already running a FIR shop business. Is a track record full of satisfaction since long. The petitioner has challenged the vacancy notification on the ground of after promulgation of National Food Security Act 2013 and Targeted Public Distribution System Controller 2015. The Controller of 2013, on the basis of which the vacancy has become redundant. I am aware of the fact that the same issue are involved in the batch of appeals pending before the Learned Division Bench in MAT number so and so. The Honorable Division Bench, if the appeal has passed an interim order, thereby directed the state authority not to dealing with any ration card holder from any dealer, as well as dealers would not be dealing from the distributor upon further order. This is being the situation. It appears to me if the authority concerned proceeded to issue license in favor of third party, multiplicity of the proceedings would be propped up, as well as the order of the Honorable Division Bench would be violated. To maintain the judicial sanctity, it would be appropriate to pass an interim order in terms of an order passed by the Division Bench in MAT number 1. This is my Shitara Begum case.
Yes.
Under the above observation, the instant application being summarized disposed of, the state authority is thereby directed to follow the direction of the Honorable Division Bench, MAT number 1 in terms of paragraph 10, order dated 1 in the state of 1. So, in nutshell, a writ petition was filed, an interim order has been passed. Considering that an appeal, that is Kataruka case, interim order has been granted. That Kataruka matter has been disposed of. by keeping all points left open. In the meantime, my lord, another division bench in other bunch of repetition passed an interim order. An application has been filed for passing an interim order. Considering the division bench order passed in a subsequent proceedings, your lordship passed an interim order. But this order was challenged before the honorable division bench. I am handing over an order passed by the honorable division bench. Order, which is what is the order? I do not know. What
You hand over a copy.
I've handed. I can't say because a giant lawyer, I can't say anything. That has been referred to just now, my learned senior friend. Referred to is but kindly say bunch of appeals. Giant lawyer. Bunch of appeals. Then kindly come to my lord. Page 3. The names of the councils have been recorded at page 3. Then you also kindly come to page 4.
That is 1543.
Yes, my lord. 1543 Shatara Begum. But kindly come to page 4. Heard the learned advocate for the party, learned senior counsel for the private respondent submits that the interim order be clarified to apply to the appellant only and not the dealer. We have considered the rival submissions and perused the order passed by us. Though the interim order refers to dealer, the said expression means the application of not all dealers, the appellant, not all dealers. Subject to the clarification, the interim order granted earlier is extended in subsequent March. So, interim order has been granted, extended up to 31st March, so and so, and matter has been fixed on. Kindly see the next paragraph, 7th of March 2025. Now, my lord, kindly see MAT number 2193 of 2024. This is challenging your lordship's order passed in Kamalesh Chandra Fauzdar. Just I have placed before your lordship the modification order. Kindly take note of this order. Mr. Learned Senior Counsel seeks leave to appeal. He contends learned single judge misconstrued the order passed in Shatara Begum versus State of West Bengal and others, and held that the order of status quo in respect of delinking is not restricted to the appellants, but extends to all dealers in the State of West Bengal. Incorrectly interpreting the order of appropriate, the honorable judge extended the relief to the non-appellant dealers. In rebuttal, learned counsel for the respondent petitioner submits that order of the injunction has been passed on the premises similar issue are pending for consideration before the division bench. So kindly turn the page. We have been given anxious consideration to the contention of Mr. Bandhavadhyay. He is correct that the order of status quo passed in Shatara Bandhavadhyay is not an order in them and does not apply to the dealer. It applies to the appellant before the court. Then, however, the impugned injunction is not only on the ground that the status quo in Shatara Begum is applicable to all dealers. Honorable single judge rightly observed that it might create multiplicity of proceedings if an order of status quo is not passed, restraining delinking from existing dealers, akin to the interim order passed by us in Shatara Begum, as similar issue are calling out for decision in Shatara Begum as well as in the petition before the honorable single judge. When similar questions of law and fact are pending consideration in the appeal, discretion exercised by the honorable single judge to pass an order of status quo and thereby restrain the delinking from existing dealer, if not already done, cannot be said to be so arbitrary or unreasonable that it would be required interference. Moreover, in light of the state's submission that the matter is of the importance, we have fixed the hearing of the Shatara Begum on 7th March 2025. Accordingly, we do not choose to interfere with the interim order. Appellant being number so and so is disposed of, concurrent application is also disposed of. So, my lord, Fauzdar, your lordship passed an order subsequent to passing order by the honorable division bench. That was under challenge. The honorable division bench came to a conclusion. We are not going to interfere with the order passed by in Fauzdar case. Today, what is the position, my lord? Justice Joy Sengupta passed an order. Only recording therein, just I am formulating my point, my lord. First, my lord, Shakuntala Devi Katarpa. Just formulating within 2-3 minutes.
Yes.
Leave to appeal file that has been dismissed. keeping all points, including the points regarding existence of 2013 state control. During pendency of that appeal, number of writ petitions was moved. Interim order has been passed. In some cases, relying on the pendency of the appeal. In some cases, independent order taking note of under 2015 control order, there is no commission for distribution. One of that case, so far the present writ petition is concerned, not to grant license.
So Shakuntala Devi's case was the challenging the provisions that there is no provisions in the control order 2015 regarding the appointment of the distributor.
Now, Shakuntala Devi, we have challenged
What is
all
the
other points, including one point, the main point, 2013 control order is redundant.
is redundant? That is the Shakuntala Devi.
Shakuntala.
And leave to appeal against the order of Shakuntala Devi was dismissed only on the
Locus.
point of locus.
Locus.
Locus of the appellant who filed the
He is not
application.
person
He
acting.
was not the person in the writ
Yes.
petition.
Keeping all points open,
Yes.
including the point of existence of 2013
Very good.
control order, whether it is redundant or exists. But that point has not been considered till today by any of the court. Justice Joyson Gupta did not pass any order on consideration of the pendency of the Shakuntala Devi.
Yes.
Justice Sengupta recorded the submission first paragraph, passed an interim order taking note of that at the time of challenging the provisions of 2013 control order existence, another ground was also taken that 2015 control order never suggests to appointment of distributor,
Yes.
which one of the point, including the point of 2013 control order exists or not. An interim order has been passed till disposal of the writ petition, not till disposal of the appeal. Now, my lord, what happened so far this present proceedings is concerned? A writ petition has been filed in original site. Interpretation has been given before the court that there is no existence of interim order so far Justice Joyson Gupta's order is concerned. My lord, your lordship knows in terms of the Honorable Division Bench order presided over by Justice Dipankar Datta, unless all the parties, respondents are fallen into the original site jurisdiction, no writ petition can be filed. In that matter, District Controller Dinajpur was not made party. Who is the licensing authority who has been restricted to grant license during pendency of the writ petition?
Yes.
Only to avoid us so that we cannot interfere. Matter has been moved in original site. Order passed in our writ petition has been sought to be interpreted without making us party. We didn't get any opportunity to place the case, at least the judgment of the Honorable Division Bench so far Shakuntala is concerned, which no uncertain term says all points, including the points of existence of 2013 control order, left open. Justice Sengupta never says this interim order will till disposal of that. So, my lord, this is error on the face of record that this subject has not been placed before your lordship. But had there been proper assistance by the learned advocate, I should say also, when the state has passed an order instructing the district controller not to grant license till disposal of the writ petition, the fair submission would have been that unless writ petition is disposed of, there is no scope for granting any license. But it was submitted before your lordship that they are going to issue license, in spite of the fact remains that the interim order passed in that case was still in force. If you lordship once again go through the order passed by Justice Sengupta, it will be crystal clear. Today, my lord, subsequent thereto, another appeal has been filed. Your lordship's order was challenged. That has also been upheld. If, my lord, today during presidency of all these orders, all those appeals, if your lordship pass an order allowing the state to grant license, that will interfere with the order of the Honorable Division Bench. which your lordship has already stated. So my prayer would be, my lord, order passed by your lordship in the original side matter should be quashed and set aside, and all consequential steps taken subsequent thereto shall also be quashed and set aside. These are my submission before your lordship.
Yes, only one question. Whether this order can be passed in review jurisdiction.
Yes, yes. We are paying for review of the order. Let the repetition be heard.
Now, whether this order can be passed or entire order.
Your lordship can be reviewed. Only so far the order is concerned, your lordship keep the matter pending. This is the provision for review. If any order is passed on the premises, wrong premises, that can be reviewed at any point of time.
Very
The issue which is should have been brought to the notice of the court, if not brought to the notice of the court, in that case, court power is enough to interfere in his own order in a review proceedings. Review means order has been obtained without placing the entire facts or documents or materials. It is apparent that brief facts, main facts, division bench order of Justice Shakuntala is concerned was not placed before lordship. The point which ought to have been placed, the facts which ought to have been placed, the reason which should have been brought to the notice of the court. If not, then the court's power is enough to interfere with the order in a review application.
very well. That's all.
And another thing is that, my lord, after passing the order in division bench in Shakuntala Devi Kataruka, my learned friend client filed an application for additional party in my petition, that is Jayashree Gupta's order, knowing fully or well that application for additional party and vacating interim order is the only process. The division bench passed order in Shakuntala Kataruka matter 18 January 2024. Kindly take note of 18 January 2024.
Yes.
And this application for additional party filed 25th of September 2024. But had there been any case that there is no existence of an interim order, they could have filed the writ petition at that material point of time. Instead, they filed an application for additional party, knowing fully well there was an interim order. Unless the same is vacated, there is no scope for granting any license. Additional party after division bench order passed in Shakuntala Devi. Then all of a sudden, fresh writ petition in original side. Without placing all facts, an interim order has been obtained.
Okay.
My lord, these are my submissions.
Yes.
Right. Lord, we are in a review.
I come to the fact. Let me-
Just come back.
Yeah, go ahead. Say spot. We are in a review jurisdiction. So what are the guiding factors? Let's see. Then I am coming. Order 47, Rule 1.
Yes.
Any person considering himself aggrieved with this one so, and who, from the discovery of a new and important matter or evidence which, after the exercise of due diligence, was not within his knowledge or could not be produced by him at the time when the decree was passed, an order made, or an account of some mistake or error apparent on the face of the record, or for any other sufficient reason desired to obtain. This is scope. Whether these facts were within the knowledge of the court or not, that's the determination. My lord, I will come to the later. The point is that your lordship is not hearing an appeal. It is not in disguise of a, whether your lordship's order was legal or not correct, that cannot be, my lord, decided in the review petition. Whole argument was that this part was not considered, that part was not considered, that part was not considered. Well, this is the point in appeal. One can take the point in appeal
Yes.
on the legal question.
Yes.
Legality of the order. This court has committed this mistake, this court has committed that mistake. It was not brought to the notice. What do you mean? You are making an allegation against the council? Your lordship was persuaded in this manner. What is the allegation about? Against the council? Then in that case, I have to say, a coterie has been now in here. For long 3 or 4 years, a coterie is going on, led by 2 or 3 lawyers. Once Kataruka, so Kataruka get an interim order first. When Kataruka was dismissed, that was also not said. Then, Milord, it has not come when Justice Bagchi's order was there, that it was only to the that party was concerned. That was also not said. Snatching an order by few lawyers, 2 or 3 lawyers. Coterie has been made. Very unhealthy practice. Reason, so far that matter, Faujdar is concerned, that's a different thing. But that reason was not their earlier matter. I will come. I will show to your lordship. Now see the review petition itself, then I am coming, Lord, review petition order, first order. See page 12. একই তো ব্যাপার লেখাটা অন্য কথা এটা অপোজিশন kindly come to page 21.
Yes.
Affidavit of service filed on behalf of the petitioner is taken on record. All the parties responsible. It is pointed out on behalf of the learned counsel that the same issue is being deliberated upon a division bench of this court of MAT 296 of 2022. Same issues were MAT 296 of 2022. He is saying, no. Justice Joy Sengupta has independently passed an order. No. Why Justice Sengupta has passed an order? Because it has been argued by the parties there. I was not a party. Why you have not made me party? The same issue is being deliberated upon by the division of MAT 296 of 2000. The next date in the case has been fixed as well. Let this matter come up for hearing in the list under the for their parties in view of the taken up by the petitioner that under the control of the there is no provision for let the respondent not finally appoint any candidate in respect of the vacancy. However, they shall be entitled to otherwise proceed with the selection process. Therefore, Milord, kindly see this MAT was referred to. Points were same.
So your submission is the MAT order of MAT 296 of 2022 is the guiding factor for
Passing the order. That MAT has been dismissed. And showing Katuruka for 4 years, 5 years. Again, I am saying a coterie obtained one after another order, one after another order, one after another order. Not making anybody in party. Only his clients will do the business in overall West Bengal. No one will get license. Tremendously unhealthy practice has been followed in these matters. Even after dismissal, it was not pointed out to the court anywhere. Now, একটু বসবি তুই বসবি
Power of the
anyway, that's the interim order. ছেড়ে দে না ওটা
Yes.
19 January, this has been done. What for we have come to your lordship? Can you see my writ petition? That is there in the record,
Yes.
which are there and which are not there. Come to page 23. This was under challenge.
Original cited file ta din. Yes.
Similar, in connection with the food and supply device to and so under reference of caption, the understanding is direct to inform that after due consideration as per control order, application for distributorship license of Sujan Kumar Rai has been approved by the Food and Supply Department, Government of West Bengal for engagement as MR distributor and so dated 1st September 2022 in the official website as well as daily newspaper. But in view of the interim order of the Honorable High Court in the matter WPA number 1151 of 2023, license in favor of the approved application shall not be issued till the disposal of the said writ petition. I have challenged that. Then, my lord, kindly come. Page 24. That was also shown. Not suppression. See, Justice Sengupta passed this order. Then, my lord, page 26, Kataruka.
Shakuntala Devi Qatar.
Kataruka. Showing Kataruka 500 matters, interim orders have been taken. No one will carry business. Only 2 lawyers' clients will carry business in the entire West Bengal. Showing Kataruka, showing one crocodile, finished. One crocodile from the pond, taking away. This is crocodile. Again gone. See, we have discussed, argued the matter on merit also. However, what are the division bench has said? Now, my lord, ultimately come to page 23. Since we held that the appellant is not a person aggrieved, he had a leave to appeal.
Yes.
My lord, every time, unfortunately, this particular council obtained an interim order. I tell your lordship the fact. Whenever adjournment is sought for on my ground. No. But his case adjournment has to be accommodated. That interim order which was taken before my lord Justice Sribagnanan. And practice is this, my lord. Kindly see, I tell your lordship today. What an unhealthy practice has been developed. Now, that time Justice Sribagnanan was a puny judge. Then he became the Chief Justice. Determination went to Justice Rajsekhar Mantha. This Kataruka matter. Then said, no, my lord cannot take up this matter. This matter is assigned to Justice Sribagnanan. And we have said, we have shown to Justice Mantha, division bench. This was not assigned. This was, the then Chief Justice said, matter be placed before the appropriate bench. And bench was Justice Sribagnanan. Justice Mantha recorded everything. Then send it to the Chief Justice for taking appropriate step. Chief Justice Sribagnanan. Justice Sribagnanan, he says the point started this, the moment point started this, taken the point. Justice Sribagnanan again assigned the matter before Justice Mantha. Justice Mantha division. Justice Mantha has said, no, since they have said that this matter should be taken up by any other bench, I will not take up it. He wants an befitting bench for him. Then matter assigned to Justice Tandon. Then let Justice Tandon pass this order.
Yes.
long recourse. We will not do the matter before any other court. Then, my lord, page 34. Very good practice, my lord. Few, let us test it. When these matters, who are the parties, they have filed an application. Initially, it was Justice Vivek Chaudhary. Then, my lord, the matter came up for hearing. And when Justice Vivek Chaudhary wanted to dispose of the matter, no, not today, now, not now, not now. And Justice Chaudhary was expressing his mind against them. Waiting at the outside, taking adjournment. Then it went to the Justice Pattanayak. Today I have to tell the practice. What an unhealthy practice has been grown up. Justice Pattanayak kindly see dealt with each and every point and dismissed the writ petition. Page 34 to
Yes.
they are not coming before a lordship and saying, see, Justice Pattanayak has discussed the matter, entire thing. Fairness. What is the fairness of a council? A precedent given by a coordinate bench is binding upon you, not the interim order of any other division. Your lordship is bound by a precedent. If he is dismissed, thereafter it is gone to the appeal court will consider whether what has happened to not or not. Not the interlocutor. This is the binding nature. This has not been said to your lordships. My lord, this is binding on me. Dismiss it. We'll go to the appeal court. He is showing fairness. How much an unfair lawyer is. If a lawyer knows only to mint money, then it is very difficult. Justice Pattanayak, this was not pressed ever to your lordship. This is the judgment. I have not seen from any of the interim order. Your lordships has quoted, Justice Pattanayak has decided this. However, in view of this, I am passing an order. What, with great respect to your lordship, kindly do not take me amiss in as a part of law. It should have been pointed out and it should have been dismissed by your lordships. And thereafter, if the appeal court failed, appeal court passed an order. Binding precedent.
Yes.
And not a single mock time. I don't know, your lordships will consider, your lordships have handled this so many matters, whether your lordships have read from 34 to page 69 or not. Your lordship can recap, lordships can take it from your lordships memory. Now, my lord, see page 71. But this judgment was delivered on 2nd August 2024.
Yes.
Now see 22nd October 2024. Room inspection. All steps have been taken. Then ultimately, my lord, the order impugned I have shown to your lordship. Then, my lord, page 75, I have written the letter, re-engagement. Now, point is only to extent whether any fact has been suppressed. Read your lordship's order. Read your lordship's order. The instant writ petition is filed seeking direction upon the concerned authority to issue license in favor of the petitioner in respect of the vacancy of distributor at block Raiganj, at subdivision Raiganj in the district of Uttar Dinajpur. This order is dated, my lord,
30th of January.
30th of January. It is the case of the petitioner that the deputy director is so and so is conducting inter alia devoted so and so. It is the case of the petitioner that interim order was passed in WPA number in view of the pendency of appeal being emitted number so and so. It is a case. It is my case. I argued whether your lordship was right to accept my argument is a point of law. That cannot be decided, my lord, in the review. It's a point of law. If your lordship has committed any error in passing the order, then it's a grounds of appeal, not the review.
Yes.
Mr. Bandyopadhyay, learned senior advocate appearing for on the behalf. My lord, earlier I have shown to your lordships that impugned order, in the impugned order itself, the order of Justice Sengupta was there. Order of Justice Sengupta was in my writ petition. Your lordships have gone through that. Thereafter, your lordships have passed this order. Therefore, what your lordships have not seen, whether your lordships have not considered properly or not, is a question of law. Yes, Justice Sengupta's order was not correctly interpreted by Justice Samanto.
That is the point of appeal.
It's a point of law. It's not a matter of review. Now, Mr. Bandyopadhyay is appearing on behalf of the submitters. There is no embargo to issue license in favor of the petitioner. There is no such interim order for issuance of a license in favor of the petitioner. Mr. Bandyopadhyay also clearly submits, kindly see, that by virtue of a decision of a batch of writ petition passed in so and so, an appeal being so and so was prepared before the Honorable Division Bench, where an interim order was passed by the Honorable Division Bench for not to delink any dealers from any distributors. Although this division bench order was not referred to the impugned order, since I appeared, I know I have shown on my own. This is the fair submission. Unfortunately, so many juniors have learned from me, but not learned the etiquette, courtesy, and other things. This is unfortunate. It is unfortunate. Unhealthy baby, I have given birth of unhealthy baby.
Yes.
See, my lord, this is I have shown to your lordship. And therefore, thereafter I am submitted. Mr. Submitter, the present petitioner is not a party to the proceeding. I am not a party to the proceeding until the last day your lordship have added me as a party. So the interim order passed by the Honorable Division Act number is not effective upon the petitioner. Mr. Senior appearing for this state assembly that the authority concerned has already taken a decision for issuance of a license in favor of the so necessary order. Having heard the learned counsel for the parties, it appears to me that the impugned memo dated 8 June to specifically restrain the petitioner from issuance of a distributor license by virtue of an pending interim order. Kindly see, pending interim order passed in WPA 1151/2023. Lordship has considered that interim order of Justice Sengupta. The interim order in W was passed by virtue of pending appeal being emitted. This rapid appeal was dismissed and disposed of. Bidder ordered it, thus there is no legal impediment to issue in favor of the petition. Therefore, is it these findings is reviewable or appealable? What your lordships will review? Review your lordships' own order. And your lordships in your all order, your lordships have given a direction after interpreting the order. Whether your lordship's interpretation is correct or incorrect, can it be reviewed by your lordships? Therefore, there is no material facts which are not brought within the knowledge of your lordships. Every fact which is relevant has been brought. And there is a distinction between a lawyer and lawyer who knows which is a material fact and a lawyer doesn't know which is a material not. By making repetition of one sentence thrice or reading some irrelevant fact, it doesn't become, it is not that the other side has not shown it. And I will show it to your lordships in a review petition what is the suppression of fact. Therefore, the question is it reviewable?
Yes.
Now, see, my lord, this order was passed by your lordships on 30th January. My lord, thereafter licenses have been granted. Card has been linked with me. That is, your lordships will find at page, go to the page. From page 23. And cards have been detached when it was communicated, my lord. Kindly see, in compliance with the order dated 30th January passed by the Honorable High Court at Calcutta, so and so, with newly appointed MD Sujan Chandra is as follows. Now, my lord, just a opposition to him. This is on 12th February 2025. Opposition আগে দিয়েছিলেন তো এইমাত্র যেটা দিয়েছে অত নিচে দেখবেন না এইমাত্র দেওয়া হয়েছে জজ সাহেবকে উপরে দিয়েছেন
Yes, you are referring page.
25.
Yes.
25A, 25B. Now, my lord, kindly see page 26. Yes, file an application on 10th February 2025. এটা কবে হয়েছিল আমি এই অ্যাপ্লিকেশনটা জজ সাহেব শুনেছিল যে ওটা লাগি আছে আসছে কোনটা kindly similar page 26 an application for appropriate order. Now kindly come to its petition. বুঝছি না আমি এরকম করলাম ছেড়ে দিয়ে বসতে তুই কর paragraph 4 kindly come. Your petitioner said that appeal being MAT number so and so, but he is saying kindly come to paragraph 3. Your petitioner said that that was taken up for hearing by his lordship the Honorable Judge Joy Sengupta on 19 January to when his lordship after hearing is made on behalf of both the parties was pleased to pass an interim order thereby directing the state tribunal not to finally so and so they shall be. This said the appeal being MAT number so and so was taken up for hearing by the Honorable Division bench so and so when the Honorable Division after hearing that is dismissal of the appeal. Then paragraph, your petitioner says that identical writ petition challenging different vacancies in different locations issued by this application. That is, some of the writ petitions are taken up for final up with the Honorable Mr. Bivas Patnaik and by delivering that way, his lordship, the Bivas Patnaik was pleased to dismiss those writ petitions. Why? Has he annexed the copy? Now see, your petitioner challenging the judgment is so and so. Those appeals and the concerned application are taken up by the division presided over the Lordship Justice Joymallo Bagchi and the Honorable Justice Gaurang Khan on 8/6 when the Honorable Division which was pleased to pass an interim order so and so. Your petitioner states that in terms of the order of the Honorable Division in identical writ petition, this Honorable Court in several writ petition was pleased to pass the interim order restraining the state respondent from granting license till the disposal of the batch of appeals pending before the so-and-so, however, response authority may proceed with the selection process. Here what has happened with why this interact now? License has been granted. Linking has been made. If the order was so bad, they could have gone to the appeal court. Now similar. See, paragraph 10. Your petitioner says that your petitioner are the similarly present circumstance and your petitioner in the writ which is pending were challenged to answer have been calculated whether I can understand so. As such petitioner cannot be treated discriminatingly. He is not a similarly person. Here the license has been granted. Yet the all consequential steps have been taken. They were not. Now, my lord, this application was taken up for hearing by your lordship. My lord, kindly come to page 32. An order to issue reimposing the interim order saying the vacancy declares a notice. He is very clear that interim order was not there in view of the division bench order. Therefore, reimpose it. He was very clear. This is his prayer. See, an order to issue restraining the interim order staying the vacancy declares notice issued by the director. He is very clear on that.
Yes.
Therefore, he was coming, but when your lordship passed an order, there was no interim order. He knows about that. Otherwise, why he should ask for a reimposition of an interim order? See the conduct. And your lordship will see page 33. 1. That I am the constituted attorney of the petition number 1 and 2. These people are constituted attorney of all the dealers. Racket is going on, racket in West Bengal. Few dealers, distributors think that they will only carry the business, no other. Court exists for all parties, by law. See, my lord, page 34. Sorry, my lord, page 46. Your lordship's order.
Yes.
The learned count, my lord, 1, 2, 3, 4. This is on 12th February 2025 morning it was done. I was at Delhi by virtually I appeared at 12th February. Learned counsel appearing on behalf of the proposed added respondent submits the license in connection with the kindly similar. Your lordship has said proposed added respondent. Submits that the license into connection with the APS has already been issued in his paper in paragraph so and so in writ petition number so and so. The petitioner intends to use opposition against the application. Date the application is fixed for hearing on February 19, 2007. Learned counsel 6 and interior in terms of the prayer made in circle. Constantly, it appears to me justifiable to fix the application which can do for hearing on February 19, 2000. The prayer for interim order can only be considered after hearing the proposed added respondents. So, your lordship did not give any interim order. But on this same day, it was taken up in the morning at 10:30. And I said, kindly pass the order. I have to go to the parliament. I was attending. Appeal division review appeal take over file. On the same day in the afternoon, my lord, the review application has been filed. Since your lordship has not passed the review. রিভিউটা দে না কিছুই তো খুঁজে পাস না 13th day of February, next day. See the conduct.
Yes.
Now, in a batch of petitions, this is the way interim order has been obtained without making the person who are the affected party say, no, no, this is at the stage of advertisement. Take an interim order and keep it in the court storage. Years after years. And I will choose the code according to my choice. Why did you not point out before Justice Bivas Patnaik when the same counsel is appearing? There are other matters also. Was it proper for a counsel? Especially for a senior advocate? No, no, I have obtained also interim order. Come on there. This is a senior advocate's role. Let us test it in this way. Keep it there. Keep it. If I fail, then I will show this batch. And not a single case, Justice Bivas Patnaik's judgment was placed before the Lords. Even not annexed. Only division bench order, division bench order, division bench order. Miller, kindly take note, kindly excuse me.
Yes.
Yesterday I came back in the night at 1 o'clock. I couldn't read anything and I could not bring it. But from my notings, other matters I am citing, just kindly take this citation, Miller. And I am testing this, kindly consider this. You see, from my left, kindly take this. I'm sorry, kindly do not mind, Miller. I have yesterday ex-Chief Justice Lalit appeared in our JPC.
I've seen your picture with the photo.
Ah, picture. But what a fantastic.
You Lalit.
Yes, yes. See, my lord, 2010, volume 13, Supreme Court cases, page 336. Santlal Gupta and others versus Modern Cooperative Group Housing Society Limited and others. Sorry, come to Miller 2007. Your lordship is 2007. He has
10 SCC 201.
201. That is Maharashtra University Health Sciences Research by Deputy Registrar versus Priyanka Mukherjee, Jawaharlal and others, Santosh Kumar and 24 other medical council. Paragraph 14. Come to paragraph 14. The High Court on earlier occasion considered the very issue relating to the validity of the clause 56(2) and 57 of the amended University Ordinance of 2003 and so. There also the MCI had supported the contention of the students. The High Court had negated the said contention and held that the clause 56, 57 are in consonance with the MCI regulation. The High Court held, apart from the fact that there is no inconsistency with the regulation 12, it will be seen that wherever the Medical Council of India or University desire to club certain assessment happens to this judgment. It proceeded to hold a student must obtain so and so, so and so, so and so. Two reasons are given for not following the earlier decision. The first is that minimum internal assessment marks required for becoming so and so regulation had given a clarification manner to give a so and so of theory and orders, practice of the order had been accepted by the Kerala High Court in case Fatima and collected in the other case. We find that neither of the two reasons given by the High Court in the said judgment are appeal for not following his earlier decision in Shital A. Abhaykar is valid. The amending to regulation reducing the eligibility bracket interest so and so. Similarly, clarification MCI supporting of the which you not refer to both the two contentions were considered and rejected merely because the Kerala High Court had accepted the clarification of the MCI. The Bombay High Court could not have ignored a binding precedent of a coordinate bench. If it wanted to take a different view, judicial propriety required the matter be referred to a larger bench. Be that as it may, we find it difficult to sustain the reasoning of the High Court in the judgment under appeal. My lord, kindly excuse me, my lord, if I use the expression, my lord, the Justice Patnaik's judgment is binding on you. If you differ with that, refer it to the division bench.
Yes.
Next judgment, my lord, 2010, 13 SCC 336. Can you give it to me, my lord? My junior. Kindly excuse me, my lord, I am not brought. 336, Santlal Gupta and others versus Modern Cooperative Group Housing Society Limited and others.
Yes.
Kindly come to paragraph 16, 17, 19. Paragraph 16. Be that as it may, the High Court has referred to its division bench judgments on be which so and so. When the same provisions had been considered, and it had categorically been held that deeming approval was not legally permissible. In view of the above, it was neither desirable nor permissible by the coordinate bench to disapprove the earlier judgment and take a view contrary to it. More so, extension of the period so and so. A coordinate bench cannot comment upon the discretion exercise or judgment rendered by another coordinate bench of the same court. The rule of precedent is binding for the reason that there is a desire to secure uniformity and certainty of law. Thus, in judicial administration precedents which enunciate the rule of law from the foundation of this administration so and so, bench so and so. Therefore, binding precedent is a but let me tell you, what I unfortunately state has also not said this. Petitioner has also not said this. Yes, this is a Justice Bivas Patnaik judgment. They could have your lordship could have, following this dismiss, go to the appeal court, take the order, same order.
Yes.
Now, my lord, I am coming to the point of review. (2024) volume 2 SCC page 362. Okay.
Yes, I have a copy.
Copy. Paragraph, my lord, kindly come. Paragraph, my lord, paragraph 7, it started, my lord, the scope of review. Kindly come to paragraph 11. My lord, kindly excuse me for one. In Perishan Devi versus Sumiti Devi, this court made very pivotal objection. Under Order 47 Rule CPC, judgment may be open to review until if there is a mistake on an error apparent on the face of the record, an error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise the power of the review under Order 47 Rule 1 CPC. In exercise of the jurisdiction under Order 47 Rule 1 CPC, it is not permissible for an erroneous decision to be reheard and corrected. A review petition, it must be remembered, as a limited purpose and cannot be allowed to be an appeal in disguise. What your lordships will consider that your lordships' judgment or order was bad. There was a mistaken error of law. Then, my lord, kindly come to paragraph 14. In Arundev Upadhyay versus Integrated so and so, From the above, it is evident that power to review cannot be exercised as an appellate or power and has to strictly confine to the purpose of ombudsman. An error on the face of record must be such an error which merely looking at the record should strike, and it should not require any long drawn process of reasoning on the points where they may conceivably by two opinions. Long argument has been made. This judgment interpretation, that judgment interpretation, this is not followed, that is not followed. What is it, an error? Apparent on the face of the record. Come to my lord, paragraph 24. Apart from the well-settled legal position that a coordinate bench cannot comment upon the judgment rendered by another coordinate bench of equal strength, and that subsequent decision or judgment of a coordinate bench or larger bench by itself cannot be regarded as a ground for review. The submission made by the learned counsel for the review petitioners that the court in the impugned decision had failed to consider the waterfall mechanism as contestable and failed to consider finding as evident from the court had considered not only the waterfall mechanism understands but also for that is a prior for the power decision. কেন এগুলো পড়াচ্ছিস আমাকে আমি বুঝতে পারছি না যা পাচ্ছিস পড়ে নি স্টার্ট এবং কত টাকা বলো কত রে then is 2024 SCC on line 1764 Justice Sanjeev Khanna and Justice Dipankar Dutt. S. Tirupati Rao appellant versus M. Linganamse and others. What paragraph? Paragraph 11. While proceeding to determine the correctness of the impugned order vis-a-vis the exercise of review jurisdiction, we ought to remind ourselves of certain cardinal principles. The exercise of review jurisdiction is not an inherent power given to the court. The power to review has to be specifically conferred by law. In civil proceeding, review jurisdiction is governed by section 114, read in conjunction with order 47 of the CPC. And the court has to certain that the elements prescribed therein are satisfied before exercising such power. Review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of order 47 rule 1 CPC. Next. Paragraph 20. Kindly come to paragraph 21. In Mirabhanja versus Nirmal Kumar Chaudhary, this court affirmed the ratio in Anirban Taluste Sharma and further expounded that the review proceedings were not by way of an appeal and should to have been strictly confined to the scope and ambit of the order of 47 rule 1 of the CPC. It was further held that an error apparent on the face of the record must be such an error which must strike on one mere looking of the record, obviating the need for long drawn reasoning of two possible opinions. This court in Horidas Das was so while rested the decision in so drew out the narrow contours of the which review application of this court had to be exercised and held that order 47 CPC does not allow for the rehearing of a dispute merely because the party had not highlighted all aspects of the case. Suppression of fact. My lord, kindly come to paragraph 82. Paragraph 82. The effect of a suppression of a material fact on maintainability of a writ petition is too well known. But what is important is whether suppression of a material fact in writ petition amounts to fraud on court and whether an issue of maintainability based on suppression can be examined if the judgment and order of disposal of the writ petition has threatened finality by reason of no appeal being carried out. Now, kindly see, my lord, if I take these principles here in review, have I committed any fraud to your lordship's court? Then it can be said to be a suppression of fact. Suppress, not persuaded in other way. Was it a material for me? On the contrary, my lord, I have fairly submitted that the another order is there. Since I appeared in the matter. But it is not the practice. It was not earlier practice. Not anywhere. You are obtaining orders because of a pendency of a matter. This is a matter, this is a matter, this is a matter. And common counsels are there. It always expects the court, other side, every prudent man, fair man expects that all that things will be brought. That have not been brought and obtained an order. Who has committed fraud? By getting all these orders? In a single case, had I been appeared, either for any of the private respondent or the state, I would have pointed out to your lordship, this is just important order. You can't go beyond that. If you want to obtain an order of appeal, obtain an order like in a go to appeal court. My lord, kindly do not mind, my lord, if I say so with great respect to your lordship, my lord, that Fauzdur's case, dear lordships, have recorded two parts. One part, that order, and second part is to avoid the multiplicity of the proceedings. Correct? Appeal court has said, this is the reason is good. But, my lord, again I am saying, as an officer of the court to assist your lordships, that when a judgment has been delivered on these issues, entertaining or passing of an interim order on that issue, on that matter, well, that would not be brought. It is a good, very good judicial discipline. Failure on the parties to bring the things before our lordship's court. This is the Justice Portnoy's judgment, my lord. And I am sure this court would not have exercised this discretion power in favor of any of the petition. What is pending to you? Pending the issues in the writ petition. Therefore, you are passing the interim order. When the issues have been decided and negative, why the court will pass the order? Because nothing is kept open to you to decide.
Your submission is that issue has been finally decided by a coordinate bench.
Which one?
The issue regarding the,
Oh, thereafter Justice Portnoy has delivered the judgment.
yes, I am saying that the issue has been decided finally by a coordinate bench,
Yes.
by Justice Portnoy.
Yes.
On above that issue, one appeal was preferred, batch of appeals or however. And in the appeals, there are interim order.
Yes, correct.
And your submission is that maybe there is an interim order, but the decision over the issue is final, attains its finality.
And that is binding on you.
That is binding upon another coordinate bench.
Another coordinate bench.
This is your submission.
Submission.
Yes.
Appeal court interim order is not. Because what you will decide, if you will not decide the appeal, you will decide the writ petition. This court will decide the writ petition. Huh? Judgment? My lord, kindly see 2007 SCC online Calcutta 267. This is a division bench judgment. Justice, no? Yeah. Presided over by Justice Bhaskar Bhattacharya. According to Mr. Mondal, a division bench of this court in the case of Paschim Bongo Rajya Samiti West Bengal report in 1912 has specifically declared the provision contained in section 14B vis-a-vis Development land is contained in section 12 of the West Bengal Reforms Ultra Virus Article 300 of the Constitution as the amount payable for acquisition land was without and just principle and also the illusory. The state cannot continue with the process to answer the another days. By relying upon the state decision, Dr. Mondal contended the order of king should be set aside. Mr. Banerjee, the learned counsel appearing on behalf of the state of West Bengal, however, opposed the opposite contention advanced by Mr. Dr. Mondal and has contended that against those two decisions, the state of West Bengal has filed applications for special leave to appeal. And in those proceedings, the Supreme Court has passed an interim order staying the operation of the orders past hearing. According to Mr. Banerjee, in view of such interim order, those two decisions are not binding upon. Therefore, the only question that arises for determination in the application is simply in an application for grant of special leave, the Supreme Court has stayed the operation of an order passed by the convener of this court, declaring such ultimately the constable as an interim measure, imposing further conditions in this case, whether a citizen who is not a party to the procedure litigation can be deprived of the benefit of the doctrine of precedent in resisting the action of the state on the ground that it could not invoke the ultra vires provisions of the statutes against him. Then we'll kindly come to paragraph 10. After hearing the learned counsel for the parties and after going through the aforesaid provisions, we find that the Supreme Court by those interim order has no doubt stayed the operation of the order of the division bench of this court by directing the parties to maintain status quo and at the same time even restrain the state from inducting third parties on the land's future in the subject matters before the apex court. Such interim order is binding upon the parties to the proceedings, but a law is equally settled that by mere passing of an interim order, staying the operation of a judgment with certain further conditions, the existence of the said judgment is not wiped out, and at the same time, for such interim orders, inter partes, the authority of a decision or as a precedent is never undermined. Unless a decision is set aside by the superior court, the said decision remains binding as a precedent, though may not be binding upon the parties to the proceeding. This said remains binding as a precedent, though may not be binding upon the parties to the proceeding, while the superior court has granted interim order. Moreover, once a provision has been declared ultra vires, the state cannot invoke the state ultra vires proceeding against the object of granting interim order is to see that the relief claimed in the appeal may be not become inappropriate or the appeal does not become infructuous for not granting such an, but by mere grant and interim stay, the effect of a binding precedent is not destabilized. Over and above the interim orders of the stay of granted by the Supreme Court clearly indicates that the state court never intended to not try to do this. Therefore, this clear. You clear?
Yes.
Go and take there. But this is the principles of law. This is binding. Therefore, my lord, what I am submitting, whoever have come after the dismissal of the Justice Tandon's order, and after delivering of the Justice Vivas Patnaik's judgment, first duty of them was to show this is Justice Patnaik's judgment. Thereafter appeal, not jumping into the appeal court has passed this order. I mean, with a great respect, again I am saying, kindly do not take me amiss, blood. I am with great respect, I am saying, when a single bench has passed an order, your lordship kindly consider that.
Yes.
If an appeal court passed an order, go and take the order from the appeal court. But whatever I am submitting, don't take it. Lord, I am trying to assist your lordship in respect of everything. What is the duty of the court? Also, I have to tell that what is the duty of the court. And here that judgment of division is that last Friday the judgment order was passed, said very clearly that was binding upon all the parties, not beyond that, which your lordship's order was there. Now, second, and all that matters. I was there on Friday when I submitted. 100 petitions are pending because of your lordship's order before the division. Then said Mr. Vandapatha, we will hear the matter on 7th. Only for 7 days.
7th of March.
This Friday. Friday. Aje kote?
Next Friday.
Next Friday. Aje ki bar? Friday week. Let them take the appeal order from the appeal court. I don't mind. We'll place our case there.
Yes.
Kindly, therefore, on different grounds, I have said there is no manifest, the error apparent on this. What the argument is, that is testing that whether your lordship's order is legally correct or not. And review cannot be appeal in disguise that I have already submitted. I have already placed all other facts. No, these are the
Yes.
submissions made by.
Yes, Mr. Sara, I reply.
No more clear. 1 and 2. 1 টা কোনটা? 1 টাতে কি আছে? The অন্য petition. There's a different petition, not this petition. Point
Yes, reply.
The first
Sir, I'm
question,
just coming after 5 minutes.
the scope of the review, my lord.
Yes.
My learned senior friend placed before your lordship order 47. Kindly take up my lord order 47. May I read, my lord? Application for review of judgment. In this case, my lord, writ petition has been disposed of by your lordship, so far the original side matter is concerned. So this is a judgment. Any person considering himself aggrieved, first question, whether I am aggrieved or not. I am aggrieved with the order passed by your lordship in the original side matter. Then, by a decree or order from which an appeal is allowed, or from which no appeal has been prepared. So order which is appealable can also be reviewed.
Yes.
But no appeal shall be filed by the person concerned. So grounds for appeal and review is same. I can choose either of the proceedings. I can file appeal, I can also file review.
Yes.
Next, by a decree or order from which no appeal is allowed, even that case review can be filed. By a declaration or reference from a court of small causes. Then, and who from the discovery of new and important matter of evidence, which after the exercise of the due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed. Pausing for a moment. Could not be produced at the time when the decree was passed. Restricted. Or order made.
Yes.
Or on account of some mistake or error apparent on the face of record, or for any other sufficient reason, desires to obtain a review of the decree passed or order made against him, may apply for a review of judgment to the court which passed the decree or made the order. Pausing for a moment, I shall go through the subsequent provisions. A person has been restricted to place some documents or materials before the court at the time of passing the decree. I am a person who obtained an order. By this way or that way, whatever may be, state was party. Interim order was still in force. That was placed before your lordship by way of filing a writ petition without making me party. Your lordship, kindly take up the review application for a moment. No, the review, not writ petition. My learned senior friend has submitted before your lordship time and again that suppression of material facts. Kindly take up the writ petition.
Writ petition.
Yes.
Yes.
Original side writ petition. Kindly turn to paragraph 11. Because no copy has been served upon us despite our repeated request. So one copy has been given to us. This is a draft copy. I don't know whether it will tell you from the original copy. Paragraph 11 starts when the petitioner further came to know.
Yes.
From the department that similar type of petition was filed before this honorable court, being WPA number so and so in respect of some books of Murshidabad district in similar conditions of vacancy notice dated so and so. On 18 September 2024, the petitioner further came to know from the department that said petition was dismissed by the honorable court and similar candidates like the petitioner herein received the license and continue their distributorship business. Upon having knowledge of the above fact, the petitioner instructed his learned advocate to make inquiry about the dismissal of the writ petition being WP number so and so, and learned advocate, after obtaining the judgment from the official website of the honorable court, inform the petitioner that the Honorable Court dismissed the said petition on 2nd August 2020 in the appearance of so and so. Thereafter, any whisper that this order has been appealed, kindly read all the paragraphs. Well known to a 6th of August, division bench interfered with the order. Is it not suppression? No whisper, no pleading. I am not saying the annexing of the document order. No whisper. This order has been interfered with by the Honorable Division Bench. 6th August, this order has been interfered with by the Honorable Division Bench. Your Lordship will not find any whisper. Kindly take up the Division Bench order. 6th August. I have handed over to your Lordship. Who are the appearing counsel? Who were the appearing counsel? Division Bench order I have given to your Lordship today. 6th of August. It was very much within the knowledge. Second page of the judgment, who are the appearing counsel? Second name for respondent number 6 in emit number so and so. Cannot say we have no knowledge about the division bench order. Second page, the names of the counsels appear. Second name, after our name. Have you Lordship got?
Yes.
Mr. Dhara was there. Suppression we have done. I have given so many examples. Then, my Lord, kindly once again taken up the review provision from the book. So, we have been restricted to place before your Lordship the division bench judgment passed by Justice Tandon along sitting with Justice, which with no uncertain terms says we are not touching the issue of 2013 control order. In the writ petition, there is no whisper. Issue was pending from the date of first filing the writ petition till today. Now, my Lord, kindly come to the order 47. 2. A party who is not appearing from the decree or order may apply for a review of judgment, notwithstanding the pendency of an appeal by some other party, except where the ground of such appeal is common to the appellant and the applicant, or when being respondent, he can present to the appellate court the case on which the appellant for the review. So, even an impugn order can be challenged by a party before the appeal court, and another party can file a review application.
Yes.
But party who is filing review application, he should not file any appeal. That's the codium. Then, kindly come to my Lord. 2. To whom application for review may be made. From the application for review, the provisions as to form of preferring application shall apply, mutatis mutandis, to application for review. Application where rejected. Kindly take note of this, is very important. Where it appears to the court that there is not sufficient ground for a review, it shall reject the application. Then 2 is very important. Application where granted, where the court is of the opinion that the application for review should be granted, it shall grant the same, provided that no such application shall be granted without previous notice to the opposite party, to enable him to appear and to heard its support of the decree or order so and so. No such application shall be granted on the ground of discovery of new matter or evidence which the applicant alleged was not within his knowledge or could not be addition by him when the decree or order was passed. In this case, we are not made party. Knowledge was with us. What is the knowledge? Kataduka without touching the issue. Division bench, not annexed, not pleaded. Not annexed, not pleaded in the writ petition. Now the question which my learned senior friend has argued before your lordship. Your lordship should not pass an interim order in any of the cases. Since all issues has been considered, Justice Patnaik dismissed the writ petition. I shall not make any further submission so far this part is concerned. That was the submission before the division bench on last occasion. And what is the division bench order?
No, that was not the submission. Don't say these things.
No, whatever maybe that is.
You are not
the
there.
aspect of the review application. I am not hearing of this.
No.
matters.
The division bench says your lordship rightly passed the order.
That is different thing.
I
There is
have
one
seen
ground.
that order.
What I am saying, the division bench says what the submission before your lordship, that when the writ petition has been dismissed, whether there is an interim order or not, by the division bench, your lordship should have taken note of the single bench judgment. It is binding upon your lordship. That has not been held by the division bench. Division bench says your lordship rightly passed the order, interim order. That is page 5 of the judgment I have given to your lordship.
Yeah.
In our page 5.
Yes.
To expedite the matter, your lordships, that submission has been considered by the division bench and upheld your lordship's order. Your lordship rightly passed the interim order in a writ petition where previous writ petition has been rejected. But division bench interfered with the order. Some judgment has been relied on before your lordship.
Yes.
So far, that point is concerned whether the writ petition order passed by Justice Patnaik is binding or not. That has been answered by our division bench. We shall proceed on the basis of the order passed by the division bench on the last occasion. That is the date of the order is, my lord, 21st of February. Another judgment has been relied upon. So far, Kolkata bench is concerned. In that case, what happened? The division bench declared a law ultra vires to the Constitution of India. There was no law after declaration of ultra vires. That matter went up to the Supreme Court. Supreme Court passed an interim order. It does not say the law which has been declared ultra vires has been become inter vires. That's the findings of the division bench. Because law which has been promulgated by the state, that has been declared ultra vires, that has been reported in, that has been placed before lordship,
2007 SCC
Yes.
online.
Yes. In that case, division bench of our High Court declared the law ultra vires. Supreme Court passed an order of stay.
Operation of the imperial
Yes.
of the state.
Yes, I'm grateful to lordship. So it does not say law became inter vires. So division bench subsequently says since it has already been ultra vires, you cannot proceed with the same. Unless it is declared inter vires by any superior court. There's no manner of application so far our case is concerned. Senior friend, it says it is appealable, you can file also review. What is the duty of the appeal court? If the appeal court is satisfied, they will quash and set aside the order. So same power enjoys by the civil court, review court. I am coming before your lordship by saying during existence of the interim order, without placing 2 orders of the division bench, without annexing the documents, order has been obtained. This is suppression. Error on the face of record. Justice Tandon clearly says issue open. So far 2013 control order existence is concerned. Another division bench, Joy Mallabakchi, interfered with the order of Justice Patnaik. That has not been annexed, that has not been pleaded in the writ petition.
No, it was argued at the time of hearing.
Yes, that's argued. I must say, my learned senior friend has placed before you. But judgment has not been produced
Yes.
How can you say I have not produced judgment?
of Justice Tandon.
What is this, my lord?
Justice Tandon's order has never been produced before you. What I am submitting, So-
Yes.
When such a lengthy hearing itself shows that the review should be rejected. There should not be a lengthy hearing of a review petition.
another paragraph of the
Anything?
Principle of law.
their opposition, I will also kindly take up. my learned friend has also submitted that we have filed an additional party, appropriate order. The same thing, after division bench judgment, additional party. In my writ petition, knowing fully well, unless the added as a party respondent and interim order is vacated, there is no scope. Because interim order passed by Justice Sengupta is still disposal of the writ petition. Following the same, after division bench judgment of Justice Chandron, they have filed an application for additional party, which is still pending. But only one paragraph of the opposition filed by them, so far my writ is concerned.
I have to ask. Which one is it? The item 1.
Affidavit in opposition.
Item 2 তো আমাদের তো আমাদের
Kindly come to my lord. Page 7.
Your lordship is also hearing the writ petition also.
No. I am reading
is-
the,
Review.
referring a opposition against review application.
Yes, opposition to the review.
Writ petition.
No,
Review app-
opposition to the review. Kindly one paragraph, page 7. In view of the letter, paragraph K, in view of the letter dated 8 June 2023, this is approval letter, which has been annexed in the writ petition.
Yes.
I filed an application for additional party in the writ petition being WP number 7. So why he has filed the application for additional party? Because in the approval letter, there is a clear rider, without disposal of the writ petition, we cannot grant license. Taking note of that, additional party has been filed, the proper recourse. So my conclusion of submission is that your lordships, if thinks that this order should not have been passed in the writ petition filed by my learned senior and client, your lordship's hand is strengthened enough to interfere with the same, quash the order, set aside the same, and also direct all consequential steps should be quashed and set aside. And another thing is that, my lord, allotment is still with me. I am distributing national articles, admitted position, even for the month of April, entire allotment has been made in my favor.
Yes.
My lord, these are my submission.
This is not the scope of review, this may be the scope of the application. And if the writ petition is concerned, one argument, his writ petition, kindly follow Justice Patnaik. Finish. Kindly follow. Ultimately, you have to decide the writ petition, follow Justice Patnaik.
I'm get close. These are my submission.
So for item 1 is concerned. So, item 1, Lordship has passed an interim order of status quo. Because of the status quo has been passed in the review petition, that's the reason one has.
No,
Your lordship-
I have heard the review. Let me dispose of the review first.
Review, my lord, today item 1 is also there.
Item
What
one.
I am submitting twofold submission. There. If your lordship delivers the judgment in favor of the petitioner, that's a different thing. But if your lordship delivers the judgment in our favor, then my lord,
Let me deliver the.
no, I am just submitting
Okay.
that they deliver the judgment. Then my lord, in that case, item 1 should also be dismissed because of Justice Patnaik's.
Division bench order is there.
Item,
Division bench, okay.
no, item 1 is a WPA.
This is a main writ petition.
WPA, item number 1 is a WPA
No, this is not the mandate
3487.
Huh?
This is not the mandate.
3487 of 2025.
No.
This is a writ petition.
That mandate by 2020, that is not appearing in the list.
And your lordship passed an order of status quo because of this. This is not that, this is not that, this is not that.
Mandate petition. is-
Ideas of so
2023.
many misleading statements have been made.
So it is need
You're
to
saying-
dispose of that
My
matter,
lord,
my lord.
This is one, item 1 is concerned main writ petition.
No. That is.
Main-
Another writ petition, I know that another writ petition.
By
Item
other
1
person.
Item 1
Petitioner
is
is also
another writ petition. Your lordship passed the status quo order because here is the review petition status quo order is there. And item 1 main writ petition is concerned.
Give me item number 1.
Item 1.
Let me see item number 1.
Item 1. Item 1 is what? কিছুই তো আনিস না। আধার মতো
Similar issue, similar order has been passed by your
Ah.
lordship.
40,000 কাগজ নিয়ে আছে, রিলিভেন্ট কাগজ আনিস। অর্ডারটা বলো।
Arthagram Samobhoy Samiti.
Yes,
Arthagram Samobhoy Samiti.
same point, your lordship have passed the status quo order. Since the review, your lordship have passed the order of status. Now, so far this part is concerned, this writ petition is concerned, I am relying upon Justice Patnaik. কোথায়? কে? কোনখানে? হ্যাঁ, সেটা হতে পারে। Now, your lordships will find Arthagram was a respondent in the earlier writ petition, where the review petition has been filed. Correct?
That is original side,
In his appellate side matter.
in his appellate side matter.
1151.
Go for one respondent.
1151 of 2023.
Ah.
Where Justice Sengupta has passed the order.
Yes.
Go for one respondent.
Now here he is the writ petitioner.
Yes.
Therefore, my lord, anyway, I am relying upon the judgment, my lord, to cut short the matter. My lord, your lordships will not rehear all the points again. That is his own object. That is his own object.
That will be
There we
interference
go.
with the
Yes,
division bench order.
That is not covered or not covered.
Interference with the division
Yeah,
bench order.
I am making a submission, Mr. Saharai. Don't try to be over smart all the time.
I have already completed my reply.
Okay, just wait.
I am talking about
Shouting will not serve the purpose.
Don't say.
I can also
Don't take questions.
Just reply. Just stop it.
After reply, no sir, further.
Don't become a meeting about us.
No, this is the item number 1.
Item number 1.
Yes.
Item number 1 was not.
Let me
Item
finish.
1, I am appearing for the respondents.
You are appearing for the respondent.
Yes.
Whether you have placed any affidavit in opposition or
So nothing.
you argue. You
Lord,
want to
this is the matter was came up for the first consideration on that day. Your lordships have passed an order of status quo.
Yes.
Correct. Because review petition has been filed. Today I am submitting that because of Justice Patnaik's judgment, this petition should be dismissed.
Okay, who is appearing for the state in this matter?
My submission would be, my lord, so far
Yes,
the
yes,
submission is concerned.
I shall hear it out. I shall hear it out. No issue. Mr. Chatterjee is appearing in this matter, I think. You are appearing in this matter? Nilotpal Chatterjee appearing in this matter. WPA 3487 of 2025. So whether this writ petition can be disposed of today, who is for the
No,
state?
writ petition has to be, my lord, my submission is this.
Your submission is the interim order can be vacated.
Interim order should be vacated and your lordships will follow the Justice Patnaik's judgment.
I am opposing this submission by saying that division bench order appeal is a continuation of proceedings. Today, there is a restriction order passed by the division bench in all matters, including the last matters. So that should be followed by your lordship.
Division bench is an interim order. It's a continuation appeal or not. Justice Bhaskar Bhattacharya has clarified that.
Justice
Yes, clarified that.
No, you have challenged in the writ, in this writ petition, you have challenged the authority.
Same notification.
Authority.
Same notification. Which was in the original writ
I am
petition.
clarifying the position.
That's
There are
not just-
4 distributors existing. Dealers will be dealing from 4 distributors. In first writ petition, 2 distributors.
Yeah, but nobody will be there. Only his people will be there. No one. This is the coterie has been made in the entire West Bengal.
Has been permitted by
Yes,
the division.
yes. Division bench permitted or not permitted, we'll see to that. There is permitted or not permitted, we'll see to that.
Okay, just.
So go on, Kotari.
Yeah.
So
Yes,
I have
Coterie master,
I have-
syndicate,
I have to-
mafia.
I have to take note of the argument of state on that point. So your submission is regarding the interim matter, interim application.
No, this is main petition.
Main writ
Status
petition.
quo should be vacated. Otherwise, problem would be there.
Because of that, the
Yes.
direction upon the state is there to file a report like that.
Yes, status quo order should be vacated.
So you are submitting today the status quo order which is
Should be vacated. My lord, let me very clear. If your lordships accept my argument in the review, it should be. If your lordship doesn't accept, then it's a different thing.
Yes, Mr. Sahara, what about your submission regarding the
So far this matter is
order of
concerned,
status quo?
your lordship, take note of same issue. Your lordship passed number of judgments, orders, interim orders that has been gone to the appeal court. Appeal court with no uncertain terms says, may I read the order, my lord? So far the division bench last order is
No, I
concerned.
know the order. I know the order.
So,
You see the order passed by this court regarding the interim order.
yes,
In the
I've seen.
at the time of passing interim order,
Fine.
this court has taken note of the pendency of WPA 1151 of 2023, as well as the disposal of WPO 53 of 2025, as well as the review application.
Fine.
Everything was taken note of
Yes.
and passed the interim order.
Yes.
So, Mr. Bandyopadhyay today submits that if the review application which you have filed gone in favor of Mr. Bandyopadhyay, the interim order passed by this court in this matter should be vacated.
But
This is his submission.
interim order has been
And what
passed
is your
not only relying on the review application.
Okay, what is your submission?
Yes. Interim order has been passed by your lordship not only relying the review application, considering the other order. Kindly see.
Okay,
So that order still exists.
that is MAT 154
Yes.
2020.
Yes. So interim order has been passed not only relying the review application, whether review application will survive or not, that is immaterial to the fact interim order will continue. These are my submission.
Okay.
Kindly read the interim order of the division bench 7. 21st February. First, kindly come to match transfer. 6. Paragraph 6. Mr. Bandyopadhyay, after passing of your lordship's order, Mr. Bandyopadhyay, Learned Senior Counsel, 6 leave to appeal. There we wanted to file an appeal. The contents learned single judge misconstrued the order passed in Sitara Begum versus State of West Bengal and others, and held that the order of status quo in respect of delinking is not restricted to the appellant, but extended to all dealers in the state of West Bengal. Incorrectly interpreting the order as aforesaid, the Honorable Judge extended relief to the non-appellant dealers. In rebuttal, Learned Counsel for the respondent request submits that the order injunction has been passed on the premises. Similar issue are pending for consideration before the division bench in Sitara Begum. Then we have given anxious consideration to the contention of the mistake. He is correct. He is correct that the order of the status quo passed in Sitara Begum is not an order in rem, does not apply to other dealers. It applies to the appellants before this court. However, the impugned injunction is not only on the ground that the status quo in state Sitara Begum is application to all the judges. Honorable Single Judge rightly observed that it might create multiplicity proceeding if an order of status quo is not passed, restraining delinking from restrictive orders akin to the interim order passed by us. So, but that matter is concerned, that reasoning was given to your lordship. In this case, that reasoning is not there. In this case, this reasoning is not there. And further development is in all cases, your lordships will know, I do not know, because I am coming. Whether Justice Portanak's judgment was placed, and today I am arguing, already argued, if Justice Portanak's judgment is there, it is a binding. Your lordships will not entertain the petition at all. Dismissed it.
Or also read the next paragraph. When similar is questions. Can I take
Okay,
note of
okay,
this?
okay.
My lord.
Yes, Mr. Chatterjee. No, the matter is that only in item number 1, WPA 3487 of 2025, Mr. Bandyopadhyay argued that the interim order in WPA 3487 2025 was passed, taking note of the pending disposal of the original side matter and the review application matter. It is submitted by Mr. Bandyopadhyay that if the review order passed in favor of Mr. Bandyopadhyay, then the interim order passed in WPA 3487 of 2025 should be disposed of and it should be vacated. And Mr. Sahara argued that the interim order in WPA 3487/25 was passed in considering other matters, that is the pendency of MAT 1543 of 2024. So the order of status quo cannot be vacated. This is the submission by both the parties. What is your stand?
That has appeared with your lordship. But I had order also reflect that I had made the submission
that in terms of court order, the judging has already happened. However, the application is allowed. That would be contrary to the order passed by the
Very.
I should not have filed a review application if his contrary order is not paid for.
You are not required to advise anyone.
Very.
You may control everyone.
with the order dated 5th of February, record by permission that has already happened.
Interim order.
So it records by permission, right? The document all the three February are passed.
Yes, I have recorded your submission. I have recorded your submission.
That date itself, I have said, we have acted upon the court order.
Yes. This is the review. রিভিউটা কোথায়? রিভিউটা দিন, এটা রিভিউ স্টে জানেন, এটা ডব্লিউপিও, তাই তো? এটা হচ্ছে অ্যাফিডেভিট ইন অপোজিশন। ওটা দিন, ওটা দিন, ওটা দিন, ওই জায়গায় উপরে দিন। হুম হুম রিভিউটা কোথায়? রিভিউটা দিন। আচ্ছা রিভিউ নো, দিস ইজ দ্য, এটা শোনেন, এটা শোনেন, ওখানে রিভিউ আছে দেখুন, ওটা হাতে হাতে রিভিউ আছে, এটা রিভিউ আছে, ডব্লিউপিও রিট পিটিশন, এটা রিভিউ।
One thing is that not your lordship on last occasion held that review is maintainable, no appeal has been prepared against that order.
No, last occasion, the two points were taken up regarding maintainability, the review
Yes,
application.
yes. That is going
These
on
two applications are disposed of. These 2 points are disposed of.
19th February.
Yes. এই রিভিউটা দিন, রিভিউটা কোথায়? রিভিউটা দিন, রিভিউ অ্যাপ্লিকেশন কোথায়? আমার কাছে তো নিচে। Okay, got it. Please take down. Review number 5 of 2025. The instant review application is preferred against the judgment and order dated 30th of January 2025 passed by this court in
Back under
WPO number 53 of 2025. Full stop. Mr. Saharai, learned counsel appearing on behalf of the petitioner, submits that this court has passed the order on 30th January 2025 wherein the review petitioner were not made party. Full stop. Submits that, yes, he submits that this court, by passing the order, impugned order, has disposed of the writ petition and directed the petitioner, directed the state authority to issue license of distributorship in favor of the petitioner. He submits that the interim order passed by a coordinate bench of this court in WPA number 1151 of 2023 restrained the department, concerned department, not to issue an license in favor of the petitioner. Full stop. He submits that the fact was not properly placed before the learned court, before this court, and this court has passed the order without considering the material point of that fact that a batch of appeals being MAT 1543 of 2024 is pending for disposal before the Honorable Division Bench, wherein an interim order was passed for not to delink any dealer from any distributors. He submits that it was argued by the petitioner before this court that the interim order was there by the coordinate bench of this court in WPA 1151 of 2023 by virtue of pendency of appeal being MAT 296 of 2022. Full stop. Mr. Saharai argued that the appeal being MAT 296 of 2022 was disposed of on a sole merit regarding the point of appellant being a person aggrieved within inverted comma. He further submits that at the time of disposal of the appeal, the Honorable Division Bench in MAT 296 of 2022 has left all point open. Full stop. In the outset, Mr. Saharai argued that there is a long-standing dispute prevailing before this court regarding the maintainability of WPDS control order, WPDS within bracket M and C control order within bracket M and C control order order করুন শুধু order M and C টা এর মধ্যে রাখুন ব্র্যাকেটের মধ্যে রাখুন WBPDS PDS within bracket M and C order 2013 after promulgation of National Food Security Act 2013 and Targeted Public Distribution System Order 2015. Full stop. The said issue was not decided by the Honorable Division Bench in MAT 296/2022. But such issue was decided by the first time by a coordinate bench in a batch of writ petition. Against the order, a batch of appeal are pending before the Honorable Division Bench, being MAT 1543/2024, wherein the Division Bench has passed an interim order directing the state authority not to dealing any dealers from the distributors. Full stop. He submits that this order is still subsisting. So in view of the interim order passed by the Division Bench, the instant order under review is defective and cannot be allowed to be continued. He further submits that the matter of decision by Honorable Division Bench and MAT 296/2022 was not placed before this court. Thus, the instant petitioner has the locus and grounds to file the instant review application. It is the contention of the learned counsel for the it is the further contention of Mr. Saharai that this court has passed the order without properly following the order of Division Bench passed in MAT 296/2022. Thus, the instant order required to be reviewed by setting aside the same. Full stop. Mr. Bandyopadhyay, learned counsel, appearing on behalf of the review, on behalf of the petitioner stroke opposite party to the review, opposite party in review application, submit that the petitioner before this court has placed the interim order passed by a coordinate bench of this court in WPA 1151/2023. Full stop. The petitioner also placed the decision passed in MAT passed by the Division Bench in MAT 296/2022. Full stop. At the time of argument, Mr. Bandyopadhyay submits, that he placed the interim order passed by the Honorable Division Bench in MAT 1543/2024. Mr. Bandyopadhyay again argued that this court has passed the order considering the entire factum of law and the orders passed by this court. He submits that if the petitioner aggrieved against the order, he must have approached before the appellate court against the order passed by this court on 30th of January 2025. Mr. Bandyopadhyay again argued that the order passed by the learned Division Bench in MAT 1543/2024 is only binding upon the parties to the appeals, being MAT 1543/2024, and not other persons, because the judgment is judgment in personam, not in judgment in rem. Judgment in personam, not judgment in rem. He further argued that the Honorable Supreme Court has, in several decisions, has clarified the position and power of review of a High Court. Mr. Bandyopadhyay placed a judgment of Honorable Supreme Court passed in Sanjay Kumar Agarwal versus State Tax Officer and another, reported in within bracket 2024 2 SCC 362. Paragraph 7, 11 and 16. 1 থেকে 16.8 পর্যন্ত। Right. Mr. Bandyopadhyay also placed a judgment of Honorable Supreme Court passed in S. Tirupati Rao versus M. Linga Maya and others, reported in 2024 SCC online SC 1764. Paragraph 11 and paragraph 21. Having heard the learned counsels for the parties, also considering the materials on record, it appears to me that this court, while passing the impugned order dated 30th January 2025, has taken note of the pendency of the interim order passed in WPA 1151 of 2023. Full stop. This court has also perused the document which was annexed with the writ petition containing the order of appeal being final order of appeal being MAT 296 of 2022. Full stop. During the course of argument, the learned counsel, Mr. Bandyopadhyay, learned counsel for the petitioner, also placed the judgment of division bench interim order of Honorable Division Bench passed in MAT 1543 of 2024. After considering the entire materials, this court has meticulously considered the interim order and is an interim order of a cornered bench passed in WPA 1543 of 2023 and has observed that there is no legal impediment to issue license in favor of the petitioner. In my view, such finding of this court is passed after considering the materials on record, and it touches the merit of the writ petition. Full stop. This court has also considered the interim order passed by the Honorable Division Bench in MAT 1543 of 2024 and has observed that the interim order in appeal is not binding upon the petitioner as he is not party to the proceeding. Full stop. In my view, full stop karo. The Honorable Supreme Court has time and again since Kamlesh Verma versus Mayawati reported in Kamlesh versus Mayawati has decided the scope of review and categorically pointed out when an application of review can be entertained. Full stop. It is categorically observed by the Honorable Supreme Court that only if a mistake or error apparent appears on the face of the record, or the final order is passed by a court which is departure from the principle of justified notion of law, or when an error which is self-evident and was detected after passing the order, such portion can be reviewed only. It is the clear finding of the court and of the Supreme Court in several matters that it is not permissible for an erroneous decision to be reheard or corrected, or a review petition cannot be allowed to be an appeal in disguise. On considering the submission of Mr. Saharai, it appears to me that Mr. Saharai has placed reliance upon the decision of the division bench of this court passed in MAT 296 of 2022, wherein no merit of the matter has been touched, and also placed reliance upon the order of division bench passed in MAT 1543 of 2024, wherein a specific direction was given to the state authority to not to delink any dealers from any distributors. Mr. Saharai submits that if such interim order is clearly followed, the order passed by this court on 30th January 2025 shall not be effective, shall not be allowed to be carried on. In my view, this court has considered the notion, has considered the binding effect of decision of division bench passed in MAT 296 of 2022, and has also consciously dealt with the direction of Honorable Division Bench in MAT 1543 of 2024, and passed a clear finding that the direction of Division Bench passed in MAT 1543 of 2024 is not binding upon the petitioner. Under the above observation, I find it justified to hold that the instant application for review and grounds thereof can be well agitated before an appellate forum, but this court lacks its jurisdiction under a review application to dispose of or determine the points as raised by the learned counsel. Moreover, I am of a view that this court cannot sit appeal over its own judgment. Under the above observation, the review application filed by the applicant is considered meritless, and the same is hereby dismissed. Dismissed and disposed of. Full stop. Latter portion I will pass after 2 p.m.
Item 8, I have mentioned all the parties there. If your lordship
I have not concluded this matter.
the 2 p.m. lawsuit has matter, 3 matter. Then another
I shall pass this order. I shall conclude this matter. Thereafter, I will take up the other matters. And other 2 p.m. matters. Okay.
There is a 2 p.m. matters, 10:30 matter.
No, what is your submission?
That is my lordship order. Fix any day, tomorrow.
Assign matters.
8.
Yes, item number 8.
Tomorrow or day after tomorrow, any day.
Tomorrow I have other matters.
Monday.
6 matters. No, a group 6 matter কি আছে tomorrow? 3 matter. Okay, tomorrow থাকবে এগুলো সব। Okay, tomorrow I'll take up.
But before my lord proceeds, my lord,
Yes.
will your lordship's endeavor be to take up the other 10:30 matter today, or it will be taken up tomorrow, my lord?
10:30 matter is there. Urgency, considering urgency, your lordship fixed. Is that it has been adjourned and your lordship.
What is the? What are the matter? 2 p.m. matter? কি matter? সেটি আছে।
Item 9, item 9,
Nine.
item number 9.
Okay, সাড়ে দশটা করি না?
আপনার 10:30
হ্যাঁ, হবে।
Some urgencies involved, but accordingly you should fix the matter. Yesterday it has been adjourned.
Okay, I will take up to item number 9
But,
after completion of this matter.
but I am in some difficult. I'm on legs. That is the
Okay.
difficult. That is why I mentioned it. Maybe taken up tomorrow at 10:30, my lord.
তোমার কি আছে?
Some urgencies involved, my lord. I have mentioned this matter.
But I have taken instruction. If it's been taken tomorrow, I don't think there's going to be any difficulty for us.
Very well, come on tomorrow then.
Tomorrow 2 p.m.
10:30.
Tomorrow 2 p.m. my lord.
2 p.m. 2 p.m. Tomorrow I have
Thursday, not origins. Just be good. It will not take some time, my lord. Because another matter is court number
2
4.
p.m. I have some original side is there.
Original side matter is not taking up.
2 p.m. original side is there.
এটা আছে।
But
Tomorrow
in that
2 p.m.
event, 1 o'clock, লক্ষ্য তোমার একটা তোমার first of all, আছে।
4:30 থাকবে। But keep it on 10:30. If any difficulties, I shall.
Yes.
Very well, very well.
Tomorrow 10:30.
Tomorrow 10:30.
But your lordship is passing order.
This matter, item number 9. This
Yes.
matter cannot be taken up today. Let the matter appear in the list tomorrow at 10:30 a.m. Item number 9. Very good. এই এটা দাও। Item number 1 টা দাও।
Your lordship passing order in Arthagram.
Yes.
I have not argued that case, but your lordship kindly see that.
Item number 3. Status code of not negative.
Item number 1 I am taking. Arthagram is you are the petitioner.
Item number 1 is a simple matter of vacancy challenging notice.
Yes.
And your lordship pass an interim order. Kindly see the order passed by your lordship on 18th February. I am handing over a copy of the order. এটা দিন your lordship. 18th February.
I'll pass the review. I have passed the review order.
Reject করে দিয়েছে।
No, my lord, actually also not vacated the interim order.
I have already vacated the and disposed of the review application, everything.
But kindly see the order. It is a simple writ petition challenging
Order
the
dated 18th of February.
Yes.
Yes.
So the interim order will extend and my lord, subject to your lordship consider, let the state file their opposition in like other matters. Your lordship taking note of the division bench order passed out.
Yes, so item number 1, Mr. Bandhavand already made the submission.
Yes.
Already made the submission.
I have not made.
Your lordship passed the status order on the basis of status order.
Absolutely not. Kindly see the order. Kindly see the order.
Yes.
No. Kindly see the order of 18th February. Considering the division bench order.
Yes.
My lord, if
There is no nexus with the review matter. And it is a simple writ petition challenging the vacancy notice. Your lordship taking note of the division bench order, pass this order. Kindly take note of the order.
lordship kindly consider this page 4.
Before that, your lordship kindly consider the entire order.
Mr. Dhara, I shall hear you. Just
Yes.
wait.
Kindly see the order. First, second paragraph, the petitioner has challenged that vacancy notification dated so and so. It is case that the petitioner that after implementation of the National Food Security Act and the Central Control Order 2020 on the basis of the which implemented. It appears that on the same issue, there were branch of petitions which was disposed of by a single bench against the said order. The petitioner of those petitions approached the Honorable High Court, and when the interim order, paragraph 10 has been quoted, not to dealing, Mr. Swanson, Learned Counsel appearing for the petitioner seeks relief in terms of the interim order of the division bench. Learned Counsel appearing on behalf of the state respondent submits that been detached, but he has not said the matter that allotment has been made. Allotment is still with me. I have received it for April also, April 2025. If further submit that as the detagging has been made, so and so, Mr. Ramesh Dhara, learned advocate for the appeal submits. Having heard the learned counsel for the parties, appears to necessary party, he has been allowed to add The petitioner please leave to correct the circular, hard copy. After considering the submission of the parties and also consideration of the matter, it appears from the submission of the learned counsel for the state authorities that so and so. Today, the interim order passed by the division bench in so and so is still subsisting. Kindly see my lord, page 3, last but one paragraph.
Yes.
Today, the interim order passed by the division bench in May so and so is subsisting. However, the honorable division bench has directed none of the ration card holders shall be dealing from the dealers, and the dealers shall not be dealing from the distributors. This order, which was passed by the honorable division bench, was considered at the time of passing of order so and so. I consider the present status of the appeals dealer, distributorship of petitioner have already been detached. The order of issue, not allotment has been made. Considering the same, there shall be an order of status quo in respect of perhaps present petitioner till tomorrow. Let the matter. This interim order has been extended. Kindly see. On the next day, this is the extension. So, your lordship, considering the common matter in the division bench, passed an interim order of status quo. What is the nexus is the review petition? This is an independent writ petition challenging the vacancy notice, considering division bench order, your lordship passed an interim order. So interim order will be extended. Let them file their report or file a affidavit. Okay. And subsequent thereto, I have already placed before lordship the order passed by your lordship division bench on 21st of February 2023 that I have handed over to your lordship 21st February 2025. Kindly see page 5. Your lordship order have been upheld. Page 5.
Well, one.
I'm Page 5 and 6, kindly see. Page 6, paragraph 8, after 4-5 lines. However, the impugned injunction is not only on the ground that the status quo in Shetarabagan is applicable to the dealers. Honorable single judge rightly observed that it might create multiplicity of the proceedings if in order status quo is not passed, restraining delinking from existing dealers. Akin to the interim order passed by us, Shetarabagan, as similar issue are failing in the decision in the Shetarabagan, falling in the decision. When similar question of law and fact are pending consideration in the appeal, discretion exercised by the honorable single judge to pass an order of status quo and thereby restrain delinking from the existing, if not already done, cannot be said to be so arbitrary or unreasonable that it would result in interference. More so. In light of the state submission that the matter of interim order have fixed the management so and so, accordingly, we do not choose to interfere in interim order passed by the learned single judge. So appeal is pending, issue is pending, independent writ petition, interim order has been passed. How it is nexus with the review application? There is no iota mentioning of the review also. Hundreds of matter in Mr. Dhara's matter also, your lordship passed similar order. There is no iota so far the review application is concerned. This is the independent writ petition by other two distributors whose dealers will be dealing if selection is made. Allotment has been made. I got the notice, my lord, kindly see, up to April.
No, this order against this order? No.
No,
No.
in respect of other matter,
Other-
that was challenged by Mr. Dhara's client, and the court held, division bench held, that interim order has been passed by the learned single, correctly passed, to avoid the multiplicity. Same issue, same writ petition, same grounds. And see, this is the allotment in my favor when it has been published. There are two. April quota has already been given to me. I am distributing since there is an order of status quo.
One single paper can show Mr. Sahara.
Whatever may be a status quo.
Just wait. Why do we?
Whatever a status quo, if he gets everything, then a status quo will go in his favor. That's the observation of your lordship. If your lordship interfere with this order, that will be interference with the division bench order. Your lordship has held, review application is not maintainable. There is good ground to prefer appeal, mandamus appeal. Does it mean, my lord, this interim order will affect for that order?
Okay.
This is the independent writ petition, independent order, considering the division bench order. Vacancy notice is under challenge.
Yes, Mr. Thar.
Roughly kindly consider your lordship passed the order on 18 February 2025. Case 2. Having heard after considering all the matter, having heard the learned counsel for the parties, it appears that Sujan Chandra Roy has newly appointed as a distributor whom some of the FPS of the petitioner was tagged. So it appears applicant is a necessary party to the matter. Accordingly, Sujan Chandra Roy be added as a party respondent number 6 to this matter. The petitioner is a leave to correct the cost item and the petitioner further subject of petition. After considering the submission of the parties and also after considering the matter, it appears from the submission of the learned counsel for the state authorities that the sum of the appeals have already been deducted from the distributor of the petitioner, and it was attached with the distributorship of added respondent. Today, the interim order passed by the division bench in MAT number so is subsisting. However, the division bench has directed none of the ration cards shall be delinking from the dealer and the dealer shall not be dealing from the distributorship. This order, which was passed by the Honorable Division Bench, was considered at the time of passing of the order of this court in WPO 53 of 2025. So this is the petition of my petition. If I consider the present status of the FPS regarding the distributorship of the petitioner, that some of FPS have already been detached, the order of status quo as on today shall not be prejudiced to any of the parties. This order, Your Lordship, passed on 18 February. DTAC has been conducted on 12 February. 12 February. Now the next paragraph. Let the matter appear in list tomorrow along with the other connected matter, being WPS such and such, WPS such and such, and review. This order accepted by the Mr. Sahara. This order accepted by the Mr. Sahara. Because your lawsuit order, review petition, and WPA 1151 and WP 343 it appear. Now both them are clubbed together. Matter has been heard. Now your lawsuit vacated the interim order passed in my review application. That status quo order bring this petition. Now Mr. Sahara want to phrase the interim order. The phrase the interim order on the basis of the order passed by the Honorable Division of the Justice Basket in another matter. This matter only license was issued. Dealer was not tagged. This matter license issued without making me party on that matter. Interim order obtained. London Division Bank said, since you have been not tagged the dealer, order is right. Here, my lord, after issuing the license, dealer has been tagged. Dealer has been tagged with me. Dealer has been detached from the Mr. Sahara client. If today any order passed by your lordship, that order should be in first order 6/8/2024. Here the division bench said, if any dealer not detached from the distributorship, if any dealer not detached from the distributorship, here my dealer already been detached. If any dealer detached by the dealer, they shall abide by the result of the appeal. Here my lord, dealer already been detached from Mr. Sahara client and tagged with my client. Therefore, my 6 August 2024 order cannot be passed here.
Okay.
I give one line reply, my lord.
Yes.
Considering all these aspects, instead of your lordship direction not to dealing, your lordship pass an order of status.
No, that's why I say your lordship cannot pass the status quo, modify the division bench order.
Okay, I have heard.
Your lordship cannot modify the division bench order.
Your lordship recorded some of the
Your
dealers.
lordship can pass the order, follow the division bench. But
I understand.
But your lordship's 18 February 2026 order, 2025 order has not been challenged when your lordship passed an order of status quo. Status quo meaning thereby whatever position on that day that will continue. I have submitted on that day. I have not been intimated whether dealers have been detached from me or not. State submitted. Some of the dealers have been detached. I have submitted before lordship. I am distributing articles to my tag dealers. Allotment is order is with me. I have handed over to your lordship also.
Yes.
Considering all these aspects and following the division bench judgment, your lordship passed an order of status quo. Not the order to not to delete. So today, what is reality? That will continue. That's the findings of your lordship, which has been extended by your lordship on the next date also. Otherwise, my lord, kindly consider all other matters. Your lordship passed the same order. This has no nexus, no relation so far the review matter is concerned. Your lordship held review is not permissible. There are grounds maybe for filing appeal. So far this writ is concerned, that has no nexus. The independent writ petition challenging the vacancy notice, order of status quo has been passed. It has been extended. Today review has been rejected. Does it mean my interim order goes? Very cautiously, your lordship passed an order of status quo. In no other matter, your lordship passed an order of status quo. What is the position that will continue at the time of filing final hearing of the writ petition? And that to 7th of March, your lordship knows division bench matter is pending. If division bench matter goes in my favor, then it will harm to me. And if it goes in favor, automatically this order will go.
Yes.
Well, these are my submission. Interim order should continue and they should file an affidavit. So far the state is concerned, like other matters.
Please take down. In number 10. Item number 1. WPA 3487 of 2025. Full stop. Petitioner challenge the action of the authority for issuing approval of vacancy of MR distributor at block Raiganj under Raiganj subdivision in district Uttar Dinajpur. Full stop. On 18th of February 2025, this court has heard the petitioner.
Well, just I'm coming back, my lord.
Yes. Petitioner as well as the state respondent and private respondent and passed an order of status quo. The reason for passing the order of status quo is that pardon? The case in hand, the case demonstrated by the petitioner is that the petitioner is a distributor who distributing ration articles over the area wherein the state respondent has approved for declaration of vacancy of MR distributor. Full stop. At the time of passing the order, it was placed knowledge under a knowledge of this court that one writ petition being WPO 53 of 2025 was disposed of by this court, wherein the petitioner of that writ petition, wherein the state authority was directed to issue license of distributorship in favor of the petitioner of that writ petition within bracket WPO 53 of 2025 in respect of block Raiganj under Raiganj subdivision district Uttar Dinajpur. Full stop. It was the contention on 18th of February 2025, it was the contention of the state authority that in terms of the order and in terms of the direction of this court in WPO 53 of 2025, the state authorities submits that some of the FPS have already been detached from the distributorship of the petitioner and is attached stroke 31 FPS কি বললাম বলো sum of the করে দাও সেটা যা আছে থাক already been detached from the distributorship of the petitioner and was tagged with the distributorship of added respondent who was the petitioner in WPO 53 of 2025. It was the contention of the petitioner before this court on 18th of February that allotment has already been given to the petitioner. Today, the matter was the WPO, no, the present petitioner has filed one review application being review 5 of 2025, which was disposed of by this court. Na review কি বললাম বলো কি বললাম না না না
But that is other petitioners, not by the
other petitioners. Okay, কি বললাম বলো না 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 to the কাটো it is also come to the knowledge of this court that some other persons, that is the other distributors, has filed an application for review being review 5 of 2025 against the final order passed in WPO 53 of 2025. At the time of taking consideration, at the time of taking note of the review, at the time of admission of the review application, an interim order of stay was passed. Full stop. Taking note of that situation regarding the issuance of license in favor of the private respondent and allotment is running with the petitioner, this court thought it appropriate to pass an order of status quo. Full stop. Next para. The review application being review 5 of 2025 was disposed of by this court today, considering the fact that the ground of review is not applicable and the review petition was disposed of. Interim order passed in the review were also vacated. Full stop. Mr. Bandyopadhyay, learned counsel appearing on behalf of the private respondent, submits that when the court has already taken a decision that order passed in WPO 53 of 2025 shall remain continued, and as the interim order passed in the review of 5 of 2025 has already been vacated, thus the order of status quo passed by this court on 18th of February 2025 need be vacated. Full stop. Mr. Sahara, learned counsel appearing on behalf of the petitioner, submits that at the time of passing the interim order, this court has not only taken note of the pendency of the not only taken note of the pendency of the review application, but also taken note of the specific paragraph, that is paragraph 10 of the order of the division bench passed in MAT 1543 of 2024. Mr. Sahara submits that the direction of the division bench has been followed by this court in passing the order of status quo. Mr. Sahara also placed order of Honorable Division Bench passed in MAT 1543 of 2024 on 21st of February 2025. He placed the relevant portion of the observation of the Honorable Division Bench at paragraph
8, paragraph 8,
paragraph 8,
8 and 9.
paragraph 8 and 9. Full stop. For better appreciation of the matter, paragraph 8 need be 8 and 9 of the order dated 21st of February 2025 passed in MAT 1543 of 2024 required to be set out. 8 and 9 to set out. I have perused the order passed by this court. Full stop. At the time of disposal of WPO 53 of 2025, this court was of view that the interim order passed by the Honorable Division Bench in MAT 1543 of 2024 was binding upon the parties to the appeal. This court has categorically observed that the petitioner of WPO 53 of 2025 is not binding over the order passed by the Honorable Division Bench in 1543 of 2024. The observation of this court has been clearly dealt with by the Honorable Division Bench in paragraph 3 of order dated 21st of February 2025 as follows. Paragraph 3 ta set out karo. Lekho bole dicchi. Paragraph 3 set out karo. We have considered the rival submissions and perused the order passed by us. Full stop. Though the interim order refers to within invited comma dealers, inverted comma close, the said expression means appellants and not all dealers. Full stop. Subject to this clarification, the interim order granted earlier is extended till 31st March 2025 or until further order, whichever is earlier. Full stop. So, after observing the entire matter in hand, it appears that by virtue of disposal of WPO 53 of 2025, the petitioner of WPO 53 of 2025 was granted license in respect of MR distributor at block Raiganj under Raiganj subdivision in the district of Uttar Dinajpur. The final order of WPO 53 of 2025 was put under question in a review, being review 5 of 2025, wherein this court has passed an interim order. To maintain the sanctity of the order passed by this court thought it fit to pass an order of status quo, though it was submitted by the state authority that during that period, the state authority has already detected some of the dealers and were tagged with the petitioner of WPO 53 of 2025. Full stop. Next paragraph. Now, after disposal of review application being 5 of 2025 and also after disposal, after vacating the interim order passed in review 5 of 2025, the final order of WPO 53 of 2025, which directed the state authority to issue license in favor of the petitioner within bracket WPO 53 of 2025, is in force if the order of status quo is being allowed to be continued in this sort, allowed to be continued, is the order of status quo passed by this court on 18th of February 2000. If the order of status quo passed by this court on 18th of February 2025 is allowed to be continued, the same shall automatically put a bar upon the final order passed by this court on WPO 53 of 2025. Under the above observation, I think it necessary, to maintain the sanctity of the order of this court, that the order of status quo passed by this court on 18th of 2025, 18th February 2025, shall not be exist at all. Under the above observation, the order of status quo passed by this court on 18th of 2025, 18th February 2025, is hereby vacated. Full stop. Let the matter, let the writ petition, let the state authority is directed to put and to file a report in the form of affidavit in the writ petition within 3 weeks from date. Let the matter appear in the list at the 3rd week of March.
I also filed affidavit in the matter.
Direction is there already, file affidavit.
I'm getting much of it.
Yes.
Later. Now your lordship pass the order rightly. Otherwise, that order will interfere with the review order. This order. If your lordship pass the order of status quo continuation, that will interfere with the review petition. Absolutely.
Yes. That is why
I'm getting lordship.
call the matters.
My lord, this was the matter, if your lordship recalls, where, my lord, this is the eviction proceedings. Eviction proceedings, my lord. I appear on behalf of the landlord. Suit for eviction, my lord, filed in the year 1995. Suit was decreed in 2005. I'll take 2 minutes. I'll just take 2 minutes, my lord. Suit was decreed in 2003. First appeal dismissed in 2004. And second appeal admitted by this court in 2005. So while admitting the second appeal, there was a direction for payment of occupational charges in 2005. So now, today we filed an application seeking for enhancement of occupational charges. So we have extensively argued this matter. And my lord, only one judgment ought to have been brought to your lordship.
May I make this clear, because he's going into the matter. I have been briefed in the matter. This is a litigation between lawyers. Your lordship will inquire why you have accepted at this stage, my lord. It's a battle between lawyers. I had to accept the brief, my lord. Now, I am praying, my lord. My senior friend will argue. If your lordship, my lord, fixes same time next week, my lord, Wednesday, I'll get ready. I am not ready because I have been briefed yesterday, my lord. I have to get ready in the matter. I've seen his application, but so if it is taken up on the next week, my lord, I'll come ready, my lord.
Very well. If you are not ready, so how can I proceed?
Naturally, my lord. This is a prayer difficult to oppose.
Okay. Let the argument be continued, pending. I make it pending regarding the argument on behalf of the petitioner.
My lord.
Your argument.
I will just take. I can put my learned friend on notice. I will not take more than 5 minutes.
Yes.
And thereafter he can.
I will have 5 minutes on that day.
Yes.
Thereafter I will start.
Very.
Okay. Please take down. Argument on behalf of the petitioner continued. Let the matter be adjourned today. List the matter on Fifth. Done. Diary.
Fifth is Wednesday, no?
Wednesday.
Yes, sir.
Fifth है, fifth शाम को जा रहा है. Fifth I'm there. Not there.
2 p.m.
So will it retain its position? Mala? Only this indulges that I see.
2 p.m. আছে কি আছে ফ্রাইডে ও না ফ্রাইডে ছেড়ে দেন কত তারিখ বললাম 5 তারিখ 11-12 দেখুন তো
আমি আগের দিন ছিলাম না, জিজ্ঞেস করে বলুন। কি আর দেখাবে, দুটো তিনটে তো আছে। আনাম সুপারম্যাক্স
দুটো নেই
না, অ্যান্ডারসন রাইট না, লাস্টে এইটা দেখায়নি কেন বুঝতে পারছি না। এটা দেখাবে
10th of March at 2 p.m.
10th March. Very well.
10th of March.
10th of March.
Let the matter be fixed on 10th of March at 2 p.m. As a specially fixed matter.
I'm grateful, man.
Yes, 10th March. Very well. Great.
Thank you.
And for the petitioner.
Hello, I'm praying for short Passover.
But you will also kindly see the last order. Last chance has been given on 17th of February 2025.
What is this?
This is matter relates to my lord. Additional commission has been withheld by the state.
Okay.
Although provided by the central government. Representative capacity, coordinate bench did not allow. Division bench interfere and says no representative capacity is maintainable.
Today is fixed for filing affidavit in opposition.
Yes, kindly see the last third
The
paragraph
state authority.
as the last
peremptorily.
chance. As the last chance.
Either I have to.
Last
start
1 year
the
it is going on, my lord. Last 1 year. No affidavit. And division bench direction is also there to file affidavit. Division bench interfere with the order of the coordinate bench and says. I've been told, my lord, Mr. Shuman Sengupta is appearing. He has some difficulties with this so far his health is concerned. But on that ground, if that
Your Lordship, Mr. Shohan Shengupta is suffering from some health issues. He couldn't appear. That's why he is asking for some time. He's praying for some
I
time, Your
understand the
Lordship.
time and accommodation is everything, but what about the affidavit in opposition?
Lordship, we will just give us in the last chance. We will try to file it by
Last
the
chance
next.
has already begun. Today is fixed
Your
peremptory.
Lordship, he couldn't appear today. That's why we had to take time.
Whatever may be learned senior advocate or advocates, that is the other issue. What about the department? Why they are not placed the affidavit in opposition? What is the status? Whether they have given the report? Do you know?
nothing.
Nothing, Lordship.
Before the division bench has report has been submitted, division bench almost settled the issue, saying that you have done the job, but money has not been paid to you. Before also kindly I have handed over the copy of the division bench. But since health ground is taking, my lord, I cannot place the case on that ground. My lord, this is an order of the division bench dated
What
18th.
is your instruction?
Your Lordship, we were instructed to take some time from your Lordship
How
because
many times?
Lordship, he is
For
actually
1
not
year.
well for a since a long time. He couldn't appear to the court as well. If your Lordship gives the last chance, we will file it for the next day.
Next day means what?
Make it, my lord, not this week. Last chance may be given, my lord.
His Lordship.
Thursday or Friday, your lordship is not taking up this matter.
So sorry, with your Lordship's leave. Lord, Mr. Sengupta is unwell, so I'm inconvenienced on that count.
I'm not about Sengupta. I want the report from the state. Why, whether they are ready or not. The
Okay,
department.
my Lord, I will come back with that instruction. My Lord, kindly records an order also, my Lord, I will just point out one thing. Publication of copy to the Manish. My Lord, if your Lordship sees the publication that has been made, copy to us. There publication to police. Perhaps, my Lord, is not in proper form because if your Lordship sees the publication, which is, my Lord, at
You can tell me. Get a that conference. So the each copy.
these are not ante bhule gaye so no
That.
no contact number has been given.
What contract number? WP number has been given, he will
No, no,
file
but-
that application.
Who will the person approach? Merely
What?
my learned senior friend intends to represent all dealers in the state of West Bengal. I understand he has made publication in one vernacular paper, but some contact details has to be there. Kindly see, Lordship, this is
How,
request of
why he will
respect.
contact me? He will file an application for addition of party.
How will he know?
That's the law.
detail?
Case number is there.
No. That is perhaps not
Everything is available in the portal.
not how
He will take
not request of
from the
respect.
order from the portal.
That is not
But
how a notice
This
is
is the
published.
stand of the state without filing any report for last 1 year. Now we are saying this advertisement is not proper. Absolutely proper.
No, I am, it is my respectful submission. My learned friend will surely differ from me. But one will kindly consider an advert and publication has been made in a writ petition seeking institution on the basis of rule under Order 1, Rule 8 in representative capacity, where other dealers are being invited to participate in the proceedings. If they so wish, where will they go? Merely, Lordship knows, not everyone is very aware of the manner in which the court proceedings are run. Most of these dealers, they are from absolute interiors or from villages.
No, if we go to explain that matter, so
I'm only on a
file
point of
the
propriety,
phone number-
nothing else. I am in
phone
your
number,
lordship's hand.
you
This
can-
I
you
understand.
can-
This is a very.
you can
I am not
argue
objecting,
that where is the
but this
mail number?
notice is perhaps
What
not
is the
proper.
address? That has to be done, but the
But a point of
tendency
contact
of
has
the
to be given
case-
at least of the learned advocate on record.
Why? Case number is there. Everything is available in the portal.
that is not the way. Very well. I will take up the matter later. So when the report would be ready, otherwise you are not ready
Lordship,
to
hard
file
ballot
the
without report on next Monday at 2 p.m. That is the direction of the division bench also.
Lordship keeps it on Tuesday instead of Monday. Come back
next Tuesday.
next Tuesday, Lordship.
Vishwanath.
time
4 তারিখে কি আসতে হবে তো?
मामला है एफआईआर को
বুঝতে চায় না সেটা বুঝে না কোর্ট রেকর্ড আমরা
তো আছে
তো রেকর্ড হয়ে গেছে তো বলতে পারি না
আর ইয়েতে 4 তারিখে 5 তারিখে then come on 5th Wednesday
at 2 p.m.
Wednesday
Wednesday at 2 p.m.
2 p.m.
Grateful.
An accommodation short for on behalf of the state respondent due to regarding medical ground of learned advocate appearing on behalf of the state. According the matter be adjourned to release the matter on 5th of March 2025 at 2 p.m. First of the state authorities directed to submit the affidavit in opposition on the adjourned date positively by supplying an advance copy to the petition.
The Lordship would kindly indicate Lordship is seeking for a report. Kindly indicates
No,
report
order
in the
is there,
field.
order is there for affidavit now.
Affidavit.
Already order is passed.
But this direction is
This
preemptory.
division bench order is there for affidavit in opposition.
Okay, I'm grateful.
Well, this direction is preemptory. So last occasion your lordship recorded that preemptory direction.
Last chance I have said.
Grateful.
Next.
6. I am for the petitioner.
But in this matter, your lordship was pleased to direct for filing of extend the time for filing AO. Now the AO is handed over to me. my
I am
lord.
handing on the
with
reply.
a advance copy to us. Just now.
I am handing over the reply, copy of the reply.
You are not ready today?
My lord, then kindly take it up any day next week.
Tomorrow? No, tomorrow is not.
Any day next week.
Next week. Thursday. 6th.
6th at 2 p.m. my lord.
6th, normally it would be appear on date. After group 6 matters, 2 or 3 matters are there. That I will take a matter. 2 matters are there. After group 6 matter, it will appear.
Interim order may be extended.
Affidavit and reply file on behalf of the petitioner is taken on record. Let the matter appear in the list under the heading 2 mentioned on 6th of March 2025. Full stop. Interim order passed by this court on the earlier occasion is further extended till
My lord, kindly for a limited period.
21st of March 2025 or until further order, whichever is earlier.
My lord. I'm get fruit.
Led by Mr. Gopal.
Yes.
My lord, in this matter, I am appearing for the petitioner, my lord. My lord,
I am here for the HPCL.
the last occasion, my lord, my learned friend, my lord, submitted a report. My lord, I have taken instruction from my client, my lord. He did not, my lord, receive any information by email, my lord. He is ready to, my lord, submit all. Last order, my lord, kindly see on.
They have sent you mails?
No, my lord, he did not receive any mails, my lord. That is why, my lord. My lord, in the meantime, my lord, he made the office, my lord, several times, and he made applications, my lord.
Yes. Vishwanath Chatterjee. Today, the HPCL supposed to file some document regarding service of mails upon the petitioners, regarding the correspondences made by the petitioners, made by the HPCL to the petitioners.
The petitioners ready to comply all the formalities, my lord, and also, my lord, he is ready to pay the deposit.
No, you put on address, email address
My lord, my lord.
in the application, and now you are saying that we have not received any application. They have sent the mail on 24th of October, and now you have filed on a representation on December. After 7 days, they must cancel your candidature.
My lord, if he, my lord, received, my lord, he must, my lord, see the office, my lord. But he was waiting, my lord, for long, my lord, after collecting his candidature, my lord. She is unemployed, my lord. She is graduate lady, my lord. She is waiting, my lord. If,
How
my lord,
graduate lady? Why? What? How waiting? There are mails numbers and they have sent the mails. There are the copy.
Unfortunately, my lord, she did not.
What
receive.
is the unfortunate matter? If you are not so serious, you are not able to run the license. All the correspondence should be done on mail. Not supposed to pass any specific order and one person shall go there and hand it over to you. Yes, what is your instruction?
I have been instructed to ask for Passover.
Huh? Passover. Okay, let it pass over.
Let make it not today, my next week, my lord.
No, let it pass it over.
My.
How this matter be? Let Mr. Chatterjee come. Pass it over. It was someone was appearing and said that he is not ready today. Tomorrow it was fixed. You are appearing for behalf of
The opposite party, my lord.
petitioner came at the morning and said he has some difficulty to do this matter today. Tomorrow it was
week, my lord. Tomorrow is another matter fixed. Already infructuous for election matter, election
Right.
already held. The office bearer already elected. And already taking charge. They are not a party in this proceeding, but already taking charge.
No, I have assured the matter will be fixed on tomorrow. I have a long hearing today on the first half.
But can we next Monday, my lord?
I have said that a matter will appear tomorrow, as you are not
I
there.
have instructions to appear on behalf of the opposite party number 7. Let it be taken up on Monday. We shall inform other side.
Okay, you inform then the petitioner, learned counsel appearing on behalf of the petitioner. Okay, let the matter. Item number 8. Though this matter mentioned in the morning at 10:30, learned counsels appearing on behalf of the respondents submits that the matter may be fixed on the next week. Concerning the
Opposite party,
submission,
my lord, opposite party, civil
respondents, no, opposite party.
Party number 1.
Concerning the submissions, the matter be fixed on 3rd of March under the same heading. Next,
This is party number 1.
call item number 12. Next,
Lordship, I am for the petitioner, Lordship.
I am led by Mr. Sahara. This is the application for addition of party. I am led by Mr. Sahara.
give me item number 12.
I am a selected candidate in respect of a fair price shop. An interim order has been passed by your lordship in respect of the vacancy. Being a proper party, I have filed this application for addition. Kindly take up my application for addition of party.
Have you served the application?
Yes. This is my
Which for the petitioner?
Thara. Mr. Somen Raj.
Mr. Raman Agarwal.
শঙ্কর দয়াল শঙ্কর ওই অ্যাডিশনাল পার্টি প্রিন্সিপাল আমাদের অ্যাডিশনাল পার্টি হ্যাঁ ওই আমরা সিলেক্টেড হয়েছে একটু পড়ে থাকবে হুম Well, kindly come to page 15 of the application.
Kindly make it not today, my lord. I am not, I don't have the brief,
Well,
man.
Have you
Only
served?
simple addition of party because I cannot pray for a
Have you served Rapute?
Yes, yes. Every service is there.
It is better you hand over a copy.
কপি আছে তো আর নাহলে দিয়ে দিচ্ছি কপি আছে নাকি দেখুন নাহলে my selection has been approved but due to interim order in respect of vacancy notification I have license has not been granted so I cannot pay for vacating of the interim order only addition of party possibly
Okay.
my learned friend will not stand on the
No question of objection, madam.
no question of objection the addition of party may be allowed let the matter will consider on the terms of the division bench order
Whatever may be, so where is your
page 15 একটাই কপি আছে approved kindly see the applicant's name Madhav Sarkar is the applicant then status current status approved have you got my
what does it mean? Finally selected.
yes but license has could not be granted since there is an interim order past page 16 page 16 is the interim order so whatever may be done that will be done in terms of the division bench order
Selected but not issued license.
yes because if there is a restriction order at page my lord 16 starts with 17 your lordship's order last paragraph last but one paragraph page 17
Very. Please take down. Can 1 of 2025.
additional
This is an application for addition of parties. Learned counsel appearing on behalf of the proposed applicant submits that the instant writ petition was preferred challenging the vacancy notification number 464 dated 25th of August 2023. Full stop. This court has passed an interim order and directed the concerned authority to proceed with the selection process, but restrain them not to issue license. He submits in terms of such procedure, the present applicant has been selected as a successful candidate. Mr. Sahara submits that as the impugned vacancy notification is under consideration of this court in this writ petition, wherein he was selected, he is a necessary party and have a right to hear the right to audience in the instant writ petition. Heard the learned counsel for the petitioner. Also peruse the peruse the screenshot of the portal wherein the present applicant was mentioned as approved in connection with vacancy ID 2022 00220508. Considering the entire aspect, it appears that the present petitioner was selected as a successful candidate in respect of the impugned vacancy notification. Accordingly, the present petitioner not only a proper party but also a necessary party to the proceeding. Accordingly, the application being can 1 of 2025 is considered and allowed. The present petitioner be made as a respondent number 5, added as a respondent number 5 of the instant writ petition. Respondent number 5 added as a respondent number 5 of the instant writ petition. Full stop. Next, by petitioner is directed to incorporate the name of the added respondent. Name of the added respondent in the cause title of the memo of the cause title of the writ petition. Full stop. Petitioner is further directed to hand over a copy of the writ petition along with the annexures thereof to the respondent number 6 within a fortnight. Let the matter go, can 1 of 2025.
Respondent number 5.
Respondent number 5. Let the
I
matter
copy-
go out of the
yes.
list party daily but can 1 of 2025.
আমার কাছে আছে
He has been selected.
yes my lord I have had a talk with him I don't know.
Yes. Next.
ফাইলটা একটু দেবেন, কারেকশন আছে।
In item number 13, Lordship, I beg to appear on behalf of the petitioner. Lordship, the petition was filed in the month of November, being the WPA number 2346 of 2024. And the matter was taken up for hearing on 19th December, and one order has been passed, Lordship. During that situation, Lordship, when the writ application was filed, it was not aware that challenging the vacancy notification upon which the writ petition has been filed, that one license has been issued in favor of a third party. Subsequently, Lordship, the interim order has been obtained. The state was there upon servicing upon the state. State has represented on that occasion on 19th December. The matter was taken up for hearing by a coordinate bench of this honorable court, and the court was inter alia pleased to pass a direction not to give a license till disposal of the MAT application which is pending before the division bench, being MAT number 1541 of 2024. Now, subsequent, Lordship, that one person who claiming that he has already issued with the license, and then after he filed 2 CAN application with a prayer, 1 CAN application with a prayer to addition of a party, and another application for the modification of the order by passing an appropriate order. Your Lordship, after filing that application, the application was taken up for 2 occasions. That first occasion when the CAN application for the addition of party has been allowed, and he has been added as a party in this matter, being the respondent number 6. Subsequently, Lordship, the CAN number 1 is also been allowed by them, Lordship. On that occasion, when the CAN application was taken for hearing, Lordship, the learned advocate for the petitioner was absent and represented by the one junior advocate. He prayed for the time, but subsequently, Lordship has heard the matter and passed an order, and this order has been there. And may I read out the portion of the order which has been passed, Lordship? And upon challenging,
No, what is today application?
Your Lordship, this application has not served, has been served upon us.
no,
You
I
have
have
not
served.
received the.
No, Lordship, this application that has been moved. before
What
your
is the
Lordship,
application? CAN 3.
can speak, your Lordship. That has not been served
You
upon.
serve a copy.
CAN 3 served upon Sonal Sinha, who is representing in this matter. I do not know that there are 3 I asked the learned advocate Sonal Sinha. She is appearing, Lordship, and he accepted the service. He accepted the service, Lordship.
Okay, okay. Served.
We have served.
Copy, your Lordship, it is not available.
That is another thing. But those persons who have represented, Lordship, we have served. I led by Mr. Sobosari Chatterjee in this matter, Lordship.
That's why I am.
No, there are some urgencies in this matter.
Supposed to serve calendar record.
But they have served upon you. They have served.
They knows about it, Lordship, and the order also, which we are seeking presently. Lordship, it is
No,
quite
what is the
gentle order.
application today you have filed?
Lordship, this application is for appropriate order. Lordship, on the last occasion, your Lordship was pleased to pass the order. Annexure P3, Lordship, please come. Annexure P3, Mr. Such and such for the appellants contains that page 28. The state has taken prevaricating stance. This is the order. Lord, you kindly come to page 18. I'm sorry, Madam. An accommodation is sought for on behalf of the petitioner. It appears that CAN 1 of 2025 is an application for modification of the order passed by this court on 19 December 2024. Mr. Such and such, learned senior counsel appearing for the added respondent submits that license in respect of the impugned vacancy has already been issued in favor of the petitioner on 14 November 2024. He further submits that on 18 November 2024, the distributor was tagged and the ration cards were also tagged. Due to the pendency of the instant writ petition, the authority concerned has withheld this allotment. He submits that the entire writ petition is liable to be dismissed as the petitioner has suppressed the material facts to the effect that they demonstrated before this court that the license was not issued. Mr. Such and Such Learned Counsel, appearing on behalf of the state, submits that the license of the impugned fair price shop has already been issued on 14 November 2024 in favor of the added respondent. I peruse the order bypassed by this court on 19 December 2024. At the last sentence, this court has observed grant of license shall abide by the result of the appeals as mentioned above. Above the said sentence, this court was of the opinion that the state authority may proceed with the selection process but without taking steps for grant of license till disposal of the appeals as mentioned above. It appears that this order was passed by this court on the basis of the submissions of the petitioner that no license was issued in favor of anyone unless which this order could not be passed. Having heard the present facts of scenario of this matter, I am of the view that the petitioner has received the order from the court on 19 December 2024 by suppressing the material facts. However, the said issue can only be ascertained by the petitioner who seeks accommodation today. So far as the present matter is concerned, as it appears that the license has already been issued, so I think it necessary to interpret the order passed by this court on 19 December 2024 more logically. The order dated 19 December 2024 has already been observed that the grant of license shall abide by the result of the appeals as mentioned above. The appeals being MAT number 1543 of 2024 is pending before the Honorable Division Bench, so it is not obligatory for the state authority to make allotment of ration articles in favor of the added respondent and carry out the same. According to the law, till the decision of the appeals of MAT such and such merit of the decision of the Honorable Division Bench, if affect the right of the license holder, may entitle state authority to take appropriate action. Hence, the application being such and such is disposed in terms of the observations made above. The state authority shall make endeavor to provide allotment as quickly as practicable considering the interest of the beneficiaries. This was the order passed. Thus, you kindly come to the order of the Honorable Division Bench, which is annexed in page 28. This is the order dated 6th August 2024.
Yes.
Mr. Such and Such for the appellants contends that the state has taken prevaricating stance with regard to full implementation of the National Food Security Act 2013. In the state, before the Honorable Supreme Court, the state had pleaded that the act has been fully implemented. However, in the written submissions placed before the Honorable Single Bench, the stance was that the act has not been fully implemented. Honorable Single Bench ought not to have relied on such submission, which runs counter to the stance taken by the state in the special leave petitions pending before the Honorable Apex Court. Mr. Such and Such, with Such and Such Learned Junior Standing Counsel, contended that the consistent stance of the state is that the act has not been fully implemented. However, steps are afoot to implement the act fully. In support of their submission, they refer to the observations in the impugned judgment that the Advocate General in the collateral proceeding had informed the court that the act has not been fully implemented. Appellants are fair price shop owners and emer distributors under West Bengal Public Distribution System Maintenance and Control Order 2013. The principal grievance is the issuance of vacancy notice under the State Control Order 2013 for appointment of the new dealers under the said order. It is contended that the State Control Order 2013 is no longer in force as the stands superseded by NFSA 2013 and the Control Order Targeted Public Distribution System Order 2015 proviso to Section 1 of Targeted Public Distribution System Control Order 2015 inter alia states Public Distribution System Control Order 2001 shall continue to have effect in any state which has not implemented National Food and Safety Standard Act 2013 or is implementing the act only in part. Appellants have sought to make out a case that the state has taken inconsistent and evasive stance in various proceedings with regard to full implementation of NFSA 2013. To clarify the position, we call upon the Principal Secretary, Food and Supplies Department, Government of West Bengal to file affidavit disclosing whether NFSA 2013 has been fully implemented in the state or not, and if the same has not been done, the reason for non-implementation in full. The affidavit shall be filed by such and such. Response to them. Now, Lordship, we direct none of the ration card holders shall be delinked from the dealers, and the dealers shall not be delinked from the distributors, if not already done for a period of 2 weeks from date until further orders, whichever is earlier. Lordship, I want this protection. That since there are two, admittedly, I have filed this petition, I obtained an order. Now, subsequently, they came before this court and said that we got the license, which is already granted in favor of my learned senior friend's client, and which was the date was prior to filing this writ petition. Now, Lordship held that it was obtained on the ground of suppression. However, Lordship has not concluded whether it is suppression or not. My case is that I did not have any knowledge about it. Who is given this or who is not given, that is not coming within my domain.
Yes.
Now, state was represented there. Good, bad, whatever it is, it was the information. Whether I have suppressed the material, whether it is a suggestio falsi or suppressio veri, that has to be decided. But at this stage, Lordship, I want the implementation of these particular observations. And Lordship, subsequently, the division bench also, subject to correction, has held that this can be done by the single bench, can consider this issue, whether this dealing. I only seek the protection regarding delinking. It should not be dealing. So therefore, all the beneficiaries who are getting the benefits through me, they should not be dealing from my zone. That is the only thing which I am trying for.
So what you want now? What is your prayer in the writ
Not
petition?
to dealing. Lordship, it's an appropriate order. Kindly come to the writ petition.
Is
My
that when you appear before this court, when you appeared admittedly before this court, license has already been granted.
that was subsequently brought before this court, brought to the notice of the court by.
Yes.
But we did not have I approached this court
Yes. You
with a
approach
clean
this
hand.
court, you
I
are-
did
you
not
are
have any
not
idea.
aware, You are not aware. You are not aware. Court also not aware.
So,
Court
so far, that is the grant of the license.
court has proceeded
State that even
to your submission.
even the division bench said that they can give the license.
If
But
not already done,
delinking was not my instruction. Till date, it is not done. So, since it is not done, let it be not.
very well.
Only thing.
Yes, anything?
Lordship, I kindly come to my the writ petition and come to this prayer of the writ petition once. In the original writ petition, Lordship, page 30. This is the prayer, and kindly come to prayer D. Prayer F. A writ in the nature of prohibition to issue prohibiting the respondents from taking any steps or further steps pursuant to the vacancy has been declared in such and such within Beldanga against the vacancy number such and such issued by the subdivision controller. An order to issue staying the vacancy. Lordship, vacancy, so far the vacancy is concerned, that is one. Kindly come to page 37 and or Lordship, kindly come to prayer J. An order to issue restraining the respondents from delinking any ration card from petitioner's fair price business. Only this protection is required by law. That is in the tune of the division bench judgment. And Lordship, kindly come to page number 21. I have annexed all the documents which shows in can 3, page 21. I have given all the documents and which shows that these are still there. We are getting allotments and it is existing. Only existing, it's kind of status quo, my lord. So far the linking and delinking is concerned. So far the grant of license is concerned, the Honorable Division Bench has said state can give, and even this court has granted. And my learned friend's case is that they have been granted with the license. Even the case of my learned friend regarding my suppression is also limited to that effect. So my lord, I only say that beneficiaries who are getting the government benefit through us, they should not be linked. That's my case, my lord. Kindly till the disposal of this case, my lord. So my lord, threefold of prayer. Lordship, the prayer in can is pass any appropriate order. Prayer J of my writ petition was that not to delink. Now, their case is that they have been granted with the license, which was a subsequent finding. Lordship, whether it is a suppression or not, that may be decided by your Lordship later on. But so far that is this grant of license is concerned, even the division bench said that it can be done. The only division bench said that this should not be delinked. Until that, there is no delink. So, Lordship, I want this status quo in this regard. Lordship, that is my submission, humble submission. Lordship, may I take your Lordship's kind leave? Lordship, my learned junior is there.
Very. Yes, Mr. Sara.
Can your Lordship taken up my lord can number 1 filed by my client?
Can number 1 is there?
Yes.
Can number 1 is disposed of, I think.
Disposed of, but documents I have annexed that has not been placed before your Lordship.
Okay.
Only to show the documents. What is the conduct of the petition?
Yes.
Page 11.
Vacancy notification.
Yes. Kindly come to page 15. Application. Date 13th October. Page 16. Offer letter. Have you Lordship got that? Offer letter. 6th of November 2024. Page 17. Money deposited. Security money. Bottom portion. Security money 25,000. License fee 10,000. Total 35,000.
Yes.
Page 19. Kindly see the date bottom. License granted. 14th November 2024. Bottom left hand side.
Yes.
Page 21. I have been tagged with the distributor. 18th November 2024. My distributor's name is Sanjay Kumar Agarwal.
Yes.
Kindly come to page 22.
Tagging.
EPOS machine and tagging. EPOS machine and tagging. Now kindly come to the order past page 24. 19th of December 2024. Entire such facts have not been suppressed. Misleading, concealing of fact. The last tagging has been done. Kindly see the date. 18th November 2024, and this writ petition was moved on 19th December, after 1 month. More so, instead of playing an order in terms of the division bench not to deter, more order has been obtained not to grant license. Kindly take note of this. Suppression, misleading, concealing of facts. At the time of moving the writ petition, not to pass the order in terms of division bench order. Rather, you passed more orders so that license cannot be granted. Had they swayed with the division bench order not to delink, I could have understood. Instead of that, a prayer has been made not to grant license.
So you are saying that dealing has already been done?
Yes. Everything has been done. Very cleverly, and thereafter, letter after letter to the subdivisional controller, there is an order of status quo not to make allotment. This should be dismissed with exemplary cost. Review what they are playing before your Lordship. Modification of order passed by your Lordship in a modified application, appropriate order. Not the clarification in respect of the order passed in the writ petition. Your Lordship has modified the order, keeping the writ petition pending. With the observation, the decision will be taken in the writ petition subject to the decision of the appeal. Now they are paying another modification. So far the modification done by your lordship with specific observation, total suppression of facts. There is no need, let the writ petition be heard. If the division bench goes against us, then definitely we shall suffer. But there is no question of interference of this order. When my person concerned coming before the court with unclean hand, they should not be allowed to make any submission even. This is a case, total suppression, misleading and concealing of facts. This application should be dismissed with limine with exemplary cost. They are not saying before lordship that we have paid something more than the division bench order. But this is deserved dismissal with exemplary cost. Because so many facts has not been brought to your lordship notice. And now my learned friend is trying to bank upon the state advocate. He should be vigilant. He should submit the proper status of the case. Instead has submitted, license has not been granted, stop him to grant license. Not only license, tagging, everything has been done.
And what about allotment, whether it was given?
Allotment has not been given since they are giving letter after letter. That not to grant license or not to make any allotment.
Okay. So who is for the
that
state?
direction has been given by your lordship, keeping the repetition pending. There is no scope.
That the allotment that time has been done. The order passed by the honorable bench. The allotment was done in favor of the petitioner lordship. But the tagging had already been done, that has not been, that order of tagging has not been done by the state authority. And I have not received the giving instruction authority to the lordship. But verbally, I have the lordship, their mind the chief taking after the order has been passed by your lordship on February 2020. But that I have to take instruction. In view of the order passed by lordship, Council just apply was not given the private report. But tagging had already been done before the petition was filed. That has been the document had already.
Now this court has passed the order on virtue of Can 1 regarding allotment.
Yes.
You have to give allotment to the private respondent.
Yes.
The direction is there.
Today or tomorrow, my allotment shall be made because previous month allotment has already been done.
So till today, no allotment is there in
Yes,
favor
sir,
of private respondent.
I don't know whether today it has been done or not. Because first week of March I have to deliver, so it will be done today or tomorrow. Now they are coming with this application.
Very.
Now, lordship, may I reply to their that what they have submitted, lordship? I can submit only few things, lordship. That first, when the writ application filed, we are not aware that the license has been granted to someone or not, because it is not a public document and is on notified in a official website or where that I can get that someone has applied in respect of one vacancy notification and license has been issued to someone, lordship. It is not in display. So it is not possible for me to get the knowledge that whether the license issued it to someone or not. Secondly, lordship, when the writ petition was filed with all the averment that not to issue a license to a third party, now state is the citizens of this matter. I have made the party, state is the party, state should have submit on that very date when the matter was taken up. They may submit that this writ petition is infructuous with this innocuous prayer as because that already this license has been issued to someone that has not been made. The state was represented. I do not know whether the state has upon instruction has submitting or represented or they have submit out of any instruction. And subsequently, lordship, that the document which I relied my senior friend, lordship, in his Can 1 application, lordship, that the document where it shows that the license has been issued in favor of him, but not a single page has been shown that any allotment has been issued in favor of him, whether the EPOS machine has been allotted to him or not, whether he have given a single, he have tagged a single person beneficiaries with his list or not. That has not been stated and that has not been shown before your lordship till date. Now, lordship, when my application will be infructuous on that ground, your lordship has taken another, that we have filed this application after obtaining leave and saying all the statement, lordship. Now, subsequently, the matter should be listed on this Monday, but lordships that could not be listed, and today's the matter is being taken up by your lordship. Now, my prayer is restricted to the particular point, as in my writ application there is the prayer then not to detach my beneficiaries. That is already in my writ application, lordship. That is alternative way, lordship, that the prayer in the first page, that whether the issuance of the license should be taken into consideration and the effect of that particular portion of the order, lordship, that is also tantamount to the detach of the beneficiary. Now, in my case, lordship, that if someone awarded with a license, he is added party in my application, lordship. I am not contradictory. I am not saying that he may not be added as a party. I am not challenging that, lordship. As they has come with the prayer that, lordship, that the person who have already awarded with the license, he may be added in my writ application, lordship. That has been allowed, lordship. I am not contradictory. I am not said any contradiction to that particular order, lordship. Subsequent order which has been passed, lordship, I am saying only the implementation of the division being judgment that, lordship, not to detach my beneficiary, lordship. That is also tantamount to the violation of the division being judgment, lordship. Now, if someone is given with the license, lordship, that effect of the license should be abide by the order of the writ application and also abide by the order of the division being judgment, as the division being need hold some observation in the bunch of writ application and bunch of appeal, lordship. My senior friend is leading all those matters. He is leading, lordship. Now, he is the respondent here in, lordship. Now, my prayer is
Now, can 3 is your prayer for appropriate
for
order?
the appropriate order. Now, lordship, what is
Appropriate order you want?
appropriate order to not to detach my beneficiary, detach the beneficiaries from.
Detagging has done.
No, detach is not
filing-
done, lordship. Let them come with an affidavit, lordship. Where the detection has been done, lordship.
State has submitted, detagging has been done.
No,
Assessment have not made. Documents are
detagging,
there.
lordship. May I read out the document, lordship? Where the detagging has been done, lordship.
Lordship, kindly take up line number 2, page 22. Different categories of page line number 2, page 22.
No,
Page 22, lordship. Yes.
I cannot understand the contents of your application being can 3. How
Appropriate
this
order.
court can entertain your
Lordship, if the beneficiaries who have been detached, but they are the beneficiary list which is tagged with my license, lordship, they are taking the benefit from my license only. That if they are saying that some person has been detached, lordship, the procedure of detach should be done through a EPOS machinery. It's a technical thing, lordship, that if one person who have awarded with a new license, he must given with a EPOS machine. And after the using of the EPOS machine, only the beneficiaries will get the benefit from him, lordship.
I have made a specific observation in can 1.
Yes, your lordship. Now,
I
what is
directed
the
the state
observation of your
authority
lordship, which I am traveling,
Make
lordship?
endeavor to
Yes.
pass an order for allotment in favor of the private.
Yes, your lordship. Now,
You are aggrieved. You can file an appeal. You go to appeal. Why by this court?
but lordship, as the division bench judgment is there, lordship, not to
If I
detach.
go to the matter merit of the division bench, I have passed the order.
Yes, your lordship can take up and pass the order, lordship. Your lordship may take my can application 3, lordship, pass the appropriate order. If it possible, lordship, that whatever lordship, I will bow down before your lordship. But my contention is very simple. What I am emphasizing, lordship, that the division bench judgment has.
Challenging an observation of this court by can 3.
No, I am not challenging, lordship. I am asking for the modification.
No, what modification
That-
you want?
What they have prayed, lordship, in their application, they prayed for our order's modification, lordship.
Forget it.
Lordship.
Order has been passed.
Order has been passed, lordship.
You
That
are agreed of the order.
no, lordship, if
Go to appeal.
now, lordship, may I subject to correction, lordship. My senior friend is there, lordship. That one order has been passed by a coordinate bench. Now their allegation is the suppression of material fact is there. Then after the order modification application has been filed, they may have also the power to move for an appeal and ask for the appeal of the order, and also they can add it as a party. Leave to appeal, they can file, lordship. They have come with an appropriate order.
If you
No, no.
challenge the order, you can challenge it.
But lordship, that the so far the operative portion is concerned, which is traveling, my lord, that only that modification will be that after observing the division bench judgment, lordship, has passed the order. That is the contradictory, lordship. May I read out the order of the impugned order where
The order is contradictory. You may prefer an appeal.
But lordship,
I have read out I have taken note of the division bench order MAT 1543 of 2024.
yes, your lordship.
In the
Now,
order
what is,
itself.
yes, your
And
lordship.
pass the
Now,
observation
what is
and
the
directed the
observation?
state authority.
Now,
If
lordship,
you are
what-
agreed, you prefer appeal. No,
but
no.
lordship,
this-
what is the observation of the division bench order, lordship? Can
No,
you
no,
consider?
I know the observation. I have
That
noted down.
observation is very simple, not to
I
delete.
know the observation. I have
Lordship.
noted down the order of the division bench, number of the order,
Lordship.
Everything is there. If you are aggrieved, you have to file an appeal, not before this court. I cannot alter my observation.
Now,
It is a
Lordship,
meticulous observation, material observation.
but
On
material
merit of the
observation is
application.
what I am troubling,
You
Lordship,
prefer,
that
no, you
that the
prefer
dealing has not been taken place. Lordship, kindly note my submission that they have what they have submitted. Lordship, the dealing has
I
not been
have
taken place.
taken
till
note the dealing. I have directed the state authority to pass an order
date. Yes,
regarding
that has not been.
allotment. Everything is there. If you are aggrieved, you have to prefer appeal. I cannot sit appeal over my order by your application only.
Lordship,
Everybody will
if
come and
Lordship, if
file
Lordship is
application
on that
for-
view, Lordship, I will bow down before your
Yes,
Lordship.
yes.
But Lordship, only that the submission may be noted, Lordship, that what I made the submission, Lordship.
Very well. Can 3 of 2024, 25? This is an application for appropriate order. Learned counsel for the petitioner submits that this code by virtue and order by virtue and application being can 1 of 2025 has passed an order on 11th of February 2025 wherein this court has modified the earlier interim order passed by this court and has directed the state authority to make endeavor to provide allotment as quickly as practicable in favor of the private respondent. Full stop. Learned counsel for the petitioner submit that this court has not considered the order of the Honorable Division Bench passed in MAT 1543 of 2024 on 6th of August 2024. He submits that the Honorable Division Bench has categorically observed that none of the ration card holders shall be delinked from any dealers if not already done. Paragraph 10 of order dated 6/8/2024 in MAT 1543 of 2024. Bracket close. He submits that the order in the order dated 11th of February 2025 is contradictory to that of the order passed by the Honorable Division Bench in MAT 1543 of 2024. So he prayed for appropriate order so that the direction of this court regarding allotment in favor of the private respondent may not be done. Full stop. Having heard the learned counsel for the parties, also considering the application being Can 3 of 2024, it appears to me that the present petitioner has challenged the merit of the order passed by this court on 11th of February 2025. The merit of this order can only be challenged in appeal. Challenged in appeal by observing the prayer in Can 3 of 2025 cannot be considered as the earlier order has already been directed the state authority to take appropriate steps. Under the above observation, I find no justification to entertain the application being Can 3 of 2025. The desired relief in Can 3 of 2025 may available in appellate jurisdiction, but not before this court. Let the matter go out of the list, parties are liberty to mention. Can 3 of 2025 disposed of. Okay. Get what you
Can 3 is disposed, Lordship. Writ petition will appear,
গোপাল নস্কর কালকে থাকবে না বলতো?
go out of list.
গোপাল নস্কর কালকে থাকবে না।
They were
Please বানিয়েছেন কার্টুন, আমি অর্ডার করলাম যে আবার লাস্টে। এই তো আইটেম নাম্বার 8, আইটেম নাম্বার 8 নাকি না, আইটেম নাম্বার 9। আচ্ছা 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 আচ্ছা।
Item number 7 and passed over.
Yes, passed over matter regarding whether any communication made like that.
Well, on the last occasion, my lord, we had handed over to them,
Copy
my
of
lord,
mails,
mails, my lord, by which, my lord, we were to intimate them. at
and
their
they are now
insistence.
saying that we have not received any mail.
Well, if your lordship kindly takes up their application form, my lord, which has been annexed.
Item number 7.
Seven.
Page 19 of the writ petition, my lord. Page 19 of the writ petition, my lord. But this is the application for appointment of the LPG distributor. But if your lordship comes right here at the bottom of the page, but column I, email ID.
Yes.
But if your lordship sees the email ID that has been given is Rabindranath Paul 67@gmail.com.
Yes, I have seen. I have seen.
But the email track report, my lord, that we have furnished on the last occasion, my lord, every time the email was being sent at Rabindranath Paul 67@gmail.com. But now, my lord, in order to give a go by, they will come and deny that we have not received it. But it is that email ID which they have provided, on which we have send them the application for award of LP. The same email ID that we have been consistently been sending them, because the letter of award says, my lord, within 7 working days, my lord, they have to deposit the money, and failing which, my lord, the letter of awards will stand cancelled. That's exactly what has happened. It has happened by operation of procedure. That's the procedural part that has been followed by.
Yes.
But my lord, just now, my lord, I have talked to the client, my lord. He again checked his number, my lord, but he did not find any, my lord, email.
You have written your email address in the application.
My lord, I have written,
It
but
is mandatory column you have filled up.
but my lord, he did not receive, my lord. If my lord, he received, my
What
lord,
not received? This is the document.
my lord,
This is the mail ID. Your mail ID is there.
my lord, it is true, my lord. But if my lord, she would, my lord, received any email, my lord, immediately she will, my lord, attend the office of the, my lord, concerned.
That is your headache. You have, why you not go there? They have sent the
but
mail.
in the meantime, my lord, he
You not require
personally,
any
my lord,
person shall go your house and hand it over to you.
my lord, in the meantime, she personally made the officer, my lord,
Whatever may be
several
the
times.
officer, what officer you, there are specific mode of communication.
But
They
my
have
lord,
adopted.
I have understand, my lord. But my lord, there is some, my lord,
If you
mistake.
some merit, if you want to place some merit that you have not received the mail like that, then you have to come with a specific application, or I find nothing in
My lord,
the
my lord, in the format, my lord, there is also, my lord, the address, my lord. My lord, the office should, my lord, send, my lord, all the paper.
Why office to address? They have sent the mail. Can you
But
deny the mail? So why you
there-
made the application in mail? The mail number is there. Mandatory column. Mandatory column, mandatory email address. You have specifically wrote down your email address.
Everything is on the online portal, nothing
Yes.
is done physically. These are floated online, participated online, communicated online, rejected also online. Everything is online portal.
And informed you online.
She is not aware with this, my lord.
What
That is
can
why, my
you
lord,
do
this,
then? Then what can you do? You want one person to go there to your home and hand over the copy of mail, copy of letter. This is the mode of communication you have to adapt to. If you are not ready to proceed
Yes,
with this
always
matter,
she is
then
ready, my lord, to.
no. Now
My lord,
your
always, my
readiness,
lord. That is
your
why, my lord,
readiness is
he
not
made several representation before the concerned authority, my lord.
several representation after the time is over. You see the time after the time is over. Your first representation in December and October 24, you have been informed.
Before that, my lord, she was personally made the office, my
What
lord.
is requirement for personally going there? Is there any direction you go to personally and persuade some person? There is no such direction in the portal.
But the office always, my lord, talk to her to. My lord,
Okay, if you want to file another writ petition, I can allow you to file it. Otherwise, I can dispose of it.
My lord, once, my lord, she must be, my lord, by the
You
concerned
have some
authority.
ground that I have not received the mail, I have debarred to receive the mail. That is altogether another aspect, but I find nothing in the writ petition.
My lord, she is waiting, my lord, since long, my lord, there. And also, my lord,
Not
the
waiting for
office.
long, just slept for a long. Okay, please take down. Petitioner applied for LPG distributor license
নম্বর দিয়েছে আবার কেন করেনি বারে পাঠিয়েছে তো দিয়েছে ওরা হ্যাঁ ওই নম্বরে
under the respondent number 2 Indian Oil Corporation Limited.
হ্যাঁ দিয়েছে
He made one online application for the LPG distributor. It is the case of the when you file online application on 28th of January 2024. Full stop. It is the case of the petitioner that he was selected in the draw of lots in respect of the said vacancy on 23rd of October 2024. Since then, she had approached several times before the office of the concerned authority, but no correspondence has been made in her favor. Accordingly, he made a representation to the Deputy General Manager, Hindustan Petroleum Corporation Limited, on 17th of February 2024, 17th of December 2024. Her representation was not answered, hence this writ. During course of hearing of this matter, learned counsel, Mr. Chatterjee appearing on behalf of the hearing of this matter, learned counsel appearing on behalf of the respondent number 2, Mr. Chatterjee, submits that the respondent number 2 submits that the petitioner was selected in the draw of lots on 23rd of October 2024. On the next day, the respondent number 2 has issued a mail, detailed mail in favor of the petitioner to his email address, to his registered email address. He placed the copy of the mail, full stop. Mr. Chatterjee further submits that it has been specifically noted in the mail that within inverted comma, please note that your candidature is liable to be cancelled in case you fail to deposit the above amount and documents listed above within 3 working days from the date of this intimation. 7 working days. কত বলেছি? 7 বলেছি? 7 working days from the date of this intimation. Inverted comma close. Mr. Chatterjee further submits that the respondent number 2 had issued the mail
Change of that letter, my lord.
Yes.
Is that paper very short handwriting as they say. Please find the attachment for security deposit letter with reference number.
Yes, he
In next page also we sent a reminder on 4th of November saying that it is a reminder for deposit security deposit for conducting bill. The reminder was also being sent.
no কি বললাম বলো না issued series of mails in the registered address, in the registered email address of the petitioners regarding receiving of application and details of draw of lots, etc. He placed the database of the copy of database of the mail. It appears that firstly on 18th of January, 28th of January 2024, one mail was sent to the email address of the petitioner, that is within bracket, within inverted comma, Robindranath Paul, PAUL, 67@gmail.com, containing that Dear Jhuma Ghosh, within inverted comma, thank you for submitting application form. Your application reference number is ... On next, the next mail was sent on 16th of October 2024 with to the same registered mail address with the intimation that within inverted comma, please find attachment for draw intimation letter with reference to your application number ... Inverted comma says. On 24th of October 2024, another same mail was sent containing inter alia that within inverted comma, hello Jhuma Ghosh, please find the attachment for security deposit letter with reference to your application number ... bracket close, inverted comma close. On 4th of November 2024, a reminder mail was issued on the same registered mail address of the petitioner containing inter alia that hello Jhuma Ghosh within inverted comma. It is reminder for depositing security deposit for conducting field verification credentials within bracket FBC for selection of LPG distributorship at Dokhin Akharbala for your application reference number such and such. Considering the entire aspect, it appears to me that the present petitioner was selected in the draw of lots and she was intimated to comply with the formalities, but the petitioner had never taken any steps At this juncture, I find no materials to entertain the petitioner. The petitioner has given her address, email address in the application itself, wherein the respondent authority has contacted. And that's score. I find no justification to entertain the writ petition. Accordingly, the instant writ petition is disposed of. Accordingly, I find no merit to entertain the instant writ petition, and the same is thus disposed of.
Obliged. This is for a subject to correction and hard respond number, or it will be respond number
3. Respond number 3 হবে।
obliged.
Next.
I am appearing on behalf of the petitioner, Miller. Last occasion, but just now I have received. I pay not to them. Otherwise,
What
Just
is the
to-
urgency of this matter? What is the matter?
Mr. Miller, the petitioner is the MR dealer. He is holding only 564 cards. According to the circular, Miller, he can hold 3,000 to 3,500. 5,000 to 6,050. Page 13, please.
You are running business with only 500 cards.
Yes, 564. In spite of vacancy has been declared, it is my submission.
It has been stated in the evidence now. Has nothing to kindly see
The page.
the history of the petitioner's termination and
That is another
reinstatement
matter.
has been
He has
stated and
reinstated.
not-
No,
which is challenging,
it is not it.
has nothing to do with the petitioner vacancy, your lordship. This is a separate idea altogether, your lordship.
Why not? Yeah.
Nothing
He is
has been
only
dealing-
holding
Your
564
lordship,
cards.
nothing has been dealing, there is no case of delinking from his
From his
or
They
his
in the
side.
same area, Miller. Can you see same area?
There is
Same.
no case made out even in the writ petition of delinking.
Yes.
Your lordship, there is
Yes.
no delinking and the resultant vacancy, your lordship, a fresh vacancy has been issued.
The kind of
What
area-
volume suspension notice was there?
No, no, they
No,
are
no, your lordship, his
That
time
was
thereafter he was reinstated.
reinstated.
yes, that's
On
that chapter is
number of
closed. That
beneficiaries.
chapter is
The
closed.
number of beneficiary has been crunched regarding his.
His vacancy has not even been touched.
Okay.
It's not
Your
dealing-
vacancy was not touched.
Malay same area he has done.
Area may be same, but your ration card was not touched.
Okay, I have not seen Miller. Can you see? No, not today. I have seen.
If there's any, it is from other which has been dealing and a fresh vacancy has been, his vacancy has not been touched.
Whether it has been stated properly.
Yes, yes.
Termination order to see.
Your lordship, kindly see page 4, paragraph 3H, your lordship.
Yes.
Your lordship, those persons have not challenged this vacancy, your lordship. He has come up with a writ application stating that no new vacancy can be. These people has not challenged this vacancy, your lordship, till date.
Okay. These DRCs are from Badal Chandra Go,
And
Narsing Kumar. Not your DRC.
nothing in connection with the
Not your ration cards.
Minute.
Not your ration card.
I pay only
Nothing
one day time. Miller. I pay only not today. Miller. I see. Just now I have received.
he is trying to get all the dealers which were not even tagged to him along with his license, your lordship, which cannot be done.
Just now I have received. Miller.
Very well. Come on tomorrow. Under the same heading.
Not this week. I said take instruction from client. Miller. Otherwise,
Your lordship, next week I am in some.
is that day after?
Second week of March. Let the matter appear in the second week of March 2024.
Yep.
Under the same heading.
Get
Second week of March 2025 under the same heading.
it.
Next.
Make it not today.
Not today. Okay. Next.
Well, in this matter, I'm filing a petition for incur my application. During pendency of the application petition, inquiry has been conducted. Therefore, my lord, in this dispute, nothing to pass direction, only direction upon the authority to conclude the proceeding within certain time.
According to the law.
According to the law.
Prematurely.
Is it the-
Affidavit of service filed on behalf of the petitioner is taken on record. Learned counsel, Mr. Dhada, appearing on behalf of the petitioner, submits fairly submits that after filing of the instant read petition, the authority concerned has issued a notice for inspection at the proposed shop cum godown of the petitioner. Also, he submits that the concerned authority was proceeding delay in filling the vacancy of the impugned vacancy notification, for which the instant read application was filed. He submits that. Next part. He submits that as the authority concerned has proceeded according to proceeded, so it is not necessary to proceed further with the read petition. Full stop. Considering the submission of Mr. Dhada, also considering the submission of Ms. Chakraborty, appearing on behalf of the state authority, it appears that the state authority has already proceeded to fill up the vacancy. Accordingly, there is no need to proceed further with this petition. Accordingly, there is no necessity. There is no necessity to proceed further with the writ petition. Let the instant writ petition be disposed of with a direction to the concerned authority to proceed with the vacancy, impugned vacancy notification according to the law.
My lord, as per my client instruction, I want to withdraw the case.
What is your name?
Jahanara Begum.
Are you advocate on record?
No, my lord. My senior, Mr. Muhammad Idris. On behalf of.
Is there any written instruction?
Instruction, my lord.
This is, my lordship, this is related to FPS case and
You are appearing on behalf of?
my senior Muhammad Idris.
Muhammad Idris. What is your name?
Jahanara Begum.
Jahanara Begum. Learned counsel, Ms. Jahanara Begum, led by Advocate on record Muhammad Idris, submits on instruction that the petitioner doesn't want to proceed further with this writ petition. Considering the submission, the instant writ petition is disposed of as not pressed.
My lord, I am
Yes, my lord. In this matter, I am appearing for the petitioner, my lord. My lord, in this matter, kindly your lordship turns the annexure P27, the impugn order, which has been passed in pursuance to lordship's order dated 13th November 2010. It is come
What is the affidavit of service?
Yes, my lord. My learned advocate and record is there, my lord. Your lordship kindly appreciate one thing, my lord. Kindly see the page 330 and second paragraph.
In the affidavit of service.
In the second paragraph, I shall
Affidavit of service.
I shall file the supplementary affidavit, my lord. There is a serious documents has been
Just wait, just wait.
Affidavit of service টা দিন।
What about the service of other respondents?
My lord, the other
There are 11 respondents.
yes, 11 responded, 8 and 9 I have served, my lord, but learned advocate not appeared. I am not finding a
And what about the other respondents, private respondents? Respondents 6, 10, 11.
my lord,
They are appearing on top of
10 may be deleted. 10 may be deleted, my lord, as because the subsequently I have received the information this is died, my lord. 10 may be deleted.
Then you correct your writ petition first.
Substitution is
Kindly give me liberty to file a supplementary affidavit, as because the after filing of writ petition, my lord, by challenging the reason order dated 2nd January 2025, regarding the second paragraph, my lord, that the serious documents has been received by the petitioner after subsequently filing the writ petition. Therefore, I am paying the leave to your lordship grant and time to file the supplementary affidavit also.
Why?
My lord, I am opposing because
Why supplementary?
The serious documents has been received with regard to the reason order. Your lordship see the reason order, page 330.
You have to appreciate this court regarding the merit of the writ petition. If it is required, then I can allow you the supplementary. The
Yes, my lord.
supplementary affidavit is only in respect of supplementary added facts, not on new facts. Okay?
Therefore, added facts. I shall add. Your lordship kindly appreciate the prayer, my lord. Kindly grant leave to file the supplementary affidavit. And in the meantime, I shall serve the copy also to the other side also.
330 pages of writ petitions and
Your lordship,
supplementary are come with a supplementary affidavit.
27. Your lordship kindly turn to the last page. Page 330.
383, my lords, in pursuant to the my lord's orders, the subdivisional controllers pass the orders, madam.
Your lordship,
383, my lords.
your lordship,
283, my lord.
page 30, 330, last page. Annexer P27.
My lord, please to come 283, my lord. There is an orders, my lord's orders is there.
Your lordship kindly see the second page.
Consonance with the my lord Guru Poroja's judgment, my lord was pleases to.
Your lordship also he turned down the order Gurudas Das and versus State of West Bengal also, which has been mentioned. Your lordship order the subdivisional controller food and supply Jalda, my lord, Purulia. So your lordship kindly.
What is the matter? What is the matter?
Matter I have challenged the reason order, my lord. Your lordship.
What is about the reason order?
Reason order kindly see last page.
Okay, just wait. Let me hear Mr. Chatterjee.
Compassionate appointment, my lord.
Matter of compassionate
Appointment, my lord.
Is there any order passed by this
Yes,
court?
my lords. My lords was page 283, my lord.
283.
283. There's the last one. And previously, a 3 or 4 litigation, 4-time litigation is there, madam. In pursuant to the my lord's orders, in light of the Guru Pada Das versus State of West Bengal, my lord SCFS Jhalda past and
283 is the last order.
Yes, my lord. And in consequence of my lord's orders, my lord 330 was passed, my lord. Subdivisional controller Jhalda, my lord. In the light of the Guru Pada Das judgment.
Where is the order? 283.
283, my lord. And the operative portion, my lord, is 285.
To ordering portion is a 285, my lord. Your lordship find it?
What is the status of the petitioner? Who is he?
Who is the
Son, my lord. He is one of the son of the
One of the heirs.
Yes, my lord.
son, my lord?
On the heir of the earlier deceased.
Your lordship kindly see the page 277, the interim order passed by the earlier judge, the Honorable Justice Bibhas Patnaik, before final disposal of your lordships.
Okay, just wait. Okay. So what is your submission? Where is he? You are appearing on behalf of whom? Respondent number 6. Ashutosh Mahato.
Ashutosh Mahato.
So there are other two petitioners, other two respondents. There are Prashanto Mahato, Monindranath Mahato, Malika Mahato. It appears that the petitioner has not served upon all the private respondents. Accordingly, petitioner is directed to serve upon all the private respondents in respect of the writ petitioners, in respect of the writ petition and annexures connected thereto. Let the matter go out of the list, parties are liberty to mention. Let the matter go out of the list. Petitioner has leave to mention the matter. Parties are liberty to mention the credit. Petitioner has leave to let the matter go out of the list. Petitioner has leave to mention the matter after completion of service. Affidavit status filed on the petitioner is taken on record.
Grateful, my lord.
Next.
Not I am for the evidence service for the evidence service.
Lordship, my senior, Mr. Suman Sen Gupta, has not come to the court because he's unwell. Kindly,
What is with you?
this is not the brief.
Okay. I think these are the reports. What is the matter?
Vacancy mailer has been notified. I have participated. I have been declared as eligible candidate, but the name of other person has been recommended, ultimately rejected. The specific case made out, his proposed shop cup go down, is not situated in the subject location.
Private respond.
Private respond. This is my specific case. I have made out the case in paragraph 20, 21, 22.
Whether any license granted?
So that instruction is not with me. Page 45 is the
Sen Gupta
rejection
has to
order.
ascertain.
But if shall I come back with the report next week?
Next week,
Let them file a report. Man. Status of the
state respondent is directed to submit the status of the notification, vacancy notification within a week. Within a week, by placing a report therein. Let the matter appear in the list on 5th of March
on the same heading.
under the same heading.
Affidavit service may be kept on record. But
Affidavit of service filed on behalf of the petitioner is taken on record.
there is a private respondent I have served. My lord. They have received.
Okay. Affidavit name.
Service. Services. I'm good.
Okay, next.
About the state watch.
23 minute, I'm the petitioner.
Yes.
They are the private respondent. They have been instructed to appear in this matter, but copy of the requisition would not be handed over to us by my client. That's not. The before yesterday they have received. Over telephone you have been instructed to appear, but copy of the requisition.
Copy, I can
Right.
give a copy here and now. And
What
I
is
don't
the
think
matter?
this is my challenging a selection process. But a copy, done. That will kindly give me a.
Can it be taken up next week? Because
The private respondent, the respondent has been selected. The challenging that this writ
the
petition is
license
being.
has been granted, I am running. So there is no scope for passing any interim order.
The only thing whether my infrastructure was worse off than that of my learned friend's client. This needs to be ascertained, my lord, because I had made an application wherein I had specifically stated that I have all the eligibility criteria. I have made an affidavit before the learned before a first class magistrate, which specifically states that I do not satisfy any of the eligibility criteria. I'll just show that I have all the eligibility criteria. I need to satisfy my lord in regard to that. I'll just come to the notification first, but my lord will kindly come to page 18.
Without ABDB cannot be valid because there is no scope for passing any
Without.
ABDB will be filed by the state and also by yours.
Let me hear it out.
Fine.
Yes. We will kindly come to page 18. It starts page 19. My lord will kindly. The eligibility criteria is there.
18 is the notification.
18 is a notification. 19 is the eligibility criteria. I'll just show that I satisfy all the eligibility criteria.
Yes.
The first eligibility criteria, I'm an individual. So an individual permanently residing at Baharampur Sodor subdivision. I specifically reside herein. In fact, I have disclosed 2 documents in support of that. I have disclosed my voter ID card, that is at page 23, and my Aadhaar card, which is at page 22, satisfying that I actually reside in this particular subdivision, Baharampur subdivision. Second is requirement of size of go down and shop running of the ration shop. Panchayat area. This is a panchayat area space of 300 square feet in regard to the go down, 100 square feet adjacent to the go down for office purposes, and a shed of 400 square feet where at least 5 persons can stand. I'll just show that I satisfy all these conditions as well. But my rent agreement is at page 25 in respect of the space. I'll just show the space measurements as well. I've pleaded that in paragraph 6. I've given the rent agreement. I've pleaded that in paragraph 6. Paragraph 6, page 7. Yes, my go down is 322 square feet, much more than that of the eligibility criteria. Height is 9 feet 6 inches. Plinth level of the space is 2 feet 10 inches from the approach road. All are much higher than the minimum eligibility criteria. The go down is also a ventilated area, pakka structure having roof made of brick slab and the floor is cemented. Accompanying office room, height is 9 feet 11 inches. Office space is 167.9 square feet, much higher than the 100 square feet area. Accompanying the office space and go down has a shed that can easily accommodate more than 5 people. So I satisfy all the eligibility criteria. And in my humble submission, when a selection has been done in respect of the private respondent, it has to be shown that the private respondent should have a better infrastructure than that of me for him to get selected. This transparency has to be there, my lord, when it comes to selection by a government body. That was never done. In fact, when I put my application code, it is just coming, I have been selected or I have been rejected, nothing else. In fact, in this particular case, I have been rejected.
Do you have any point that the selected person has not qualified or no such selection, no such eligible criteria like that?
The only thing I
may have a 7,000 square feet, but he may have 8,000 square feet.
Well, no,
Have you
that
pleaded
is
anything against the private respondent that he has a less efficient person, but he was selected?
the only
Pleaded like that?
my lord, I have.
You have not pleaded.
My lord, I have, my lord. Paragraph 15, page 9, my lord.
Paragraph 15,
Page 9. Paragraph 15 and 16.
You came to know that private respondent number 2 has been selected.
My lord. He has been selected, admittedly been selected. In fact, my learned friend has specifically said so. My rejection, I have a copy of my rejection as well. This is the very fact that the private respondent was selected was not officially made known to me, but I have come to know from reliable sources, and then now it's an
Your
admitted fact.
candidature was rejected.
My lord.
Let me call for the report from the state.
My lord.
I'm showing mine.
Everything is there. Then you have to serve upon them. Otherwise,
This has been made out that his candidature is better than.
yes.
No allegation against me that I am inferior candidate or I am not eligible.
Two last
So I want to file my opposition to this matter because I am running the. No case made out. What case has been made out? He is saying he fulfilled the condition. If 10 candidates fulfill the condition, definitely 10% will not.
Better candidate will be.
private one has a better infrastructure.
Much better. And this is not the case.
A copy may be served on me if I have a copy of that may be served.
Does not mean my lord.
So allegation
He is a better candidate.
that he is a better candidate.
My lord, kindly come to page, my lord. Page 9, my lord. the inquiry report of the petitioner. Starting from
No, I understand. If I dispose of these, that would be not good. He would be asking for the report like that, without perusing, without giving him opportunity to see the report.
I will give a copy, ma'am, but all everything is there.
This copy would not be sufficient. You have to file a report with affidavit in the form of affidavit. In the form of, otherwise this writ petition cannot be disposed of. You prefer the appeal and said, I would have nothing to, okay.
Service.
Affidavit of service filed on behalf of the petitioner is taken on record. Private respondent is represented through Mr. Sahara. State is also represented. Having heard the learned counsel for the parties, it appears that the instant writ petition cannot be disposed of effectively without giving opportunity to the opposite to the respondent to file affidavit in affidavit in opposition and a report in the form of affidavit from the state authority. Let the state authority be directed to be given a liberty to file a report in the form of affidavit within 3 weeks from date. The private respondent is also give liberty to file affidavit in opposition against the writ petition within 3 weeks. Hence, exception stroke reply, if any, by the petitioner within 2 weeks thereafter. Let the matter appear in the list. Let the matter appear in the list in the 3rd week of April 2025. April 2025. April. Deep
Point of maintainability left open because no case has been made out.
Point of maintainability as raised by the respondents are kept open. Is kept open. Yes. Call next matter.
But I am for the petition. Lord, in 24, I am appearing for the respondent number 8. I have been served the copy today itself. I am paying for 2 days accommodation.
You are for
affidavit of service, Lordship. I am for the petition. Lord, can keep the matter on next Tuesday, Lordship. I shall be.
You are appearing on behalf of
Respondent number 8.
private respondent, which for the state.
I am for the.
Lordship, may I submit one thing, Lordship? The innocuous prayer is to consider the representation made by the petitioner to the state authority, considering as there is a allegation regarding the providence of illegal financial transactions between the private respondent and the authority, and as per instruction that the private respondent has already granted approval. So if the state can consider my representation and pass a reason order so that I can
What is the
substantiate.
fact about the
Lordship,
private respondent was selected?
during
Approved, my Lord.
approved.
You will find page 7.
Approved.
Approved. For recommendation.
So selected candidate.
Selected candidate. I do not know whether license has been granted or not, but it
No,
appears
no.
from page 7. Page 7, para 12.
Okay.
Lord,
The
in the
private
mean-
respondent was selected.
Selected.
Very well.
Now for the recommendation. Now thereafter, my Lord, my learned friend made a representation at page 35.
Yes.
My Lord, alleging certain things, my Lord, for consideration, my Lord, for this. It's a minister in charge, not this one.
No. Copy.
Minister in charge?
No. There are copy to last test.
All copies to the minister
All,
in charge.
yes, that is a, let him, my Lord.
No. The copy was forwarded to other state authorities, Lordship.
Should address it to the Director Food and
Food and
Supply.
Supply.
Matter could be adjourned till Tuesday. বাবা, এটা তো কিছু করছেন না।
Page 35, my lord, and on any representation, if your lordship.
Several grounds are stated.
Several
there.
grounds, my lord, I found that distance, then some deeds, my learned friend has referred to. Then
These are my eligibility
there are
criteria.
other issues. This can be considered, my lord, in accordance with the after extending an opportunity to the private respondent.
To take the mic, I cannot hear it.
Gives this matter on Tuesday, your lordship, I shall apprise this court. I haven't gone in, I haven't have any opportunity to go through the brief, your lordship. I've just briefed today itself.
Or your lordship send it back to the authority concerned after
Kindly-
giving opportunity of hearing to all the party concerns, the state authority will consider.
Kindly consider my prayer. Keeps it on Tuesday, your lordship, I shall apprise this court.
That is. To answer. Let the matter appear in the list. No, affidavit of service filed on the behalf of the petitioner is taken on record. Let the matter appear in the list on 4th of March under the same heading.
Great.
Call the list. And I am the petitioner, madam.
I appear on behalf of the state, your lordship.
And almost a similar application. This is I have been rejected in this case also. Page 33, I have the eligibility criteria I've pleaded, I've given all documents.
Your
to the
lordship, the
evidence.
report is with me. The person who has been given the license had much better qualifications. He had scored 82, whereas the petitioner had scored only 66 marks. Your lordship, all the details are there. The report has been made available, your lordship.
Report. You
I
file
shall
the
file a
report in the form of affidavit.
Yes, your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Concerning the submission of the parties, it appears that the instant writ petition cannot be disposed of without giving the state authority to file a report in the form of affidavit. Let the report in the form of affidavit be filed within 3 weeks from date. Reply, exception if any, by the petitioner within 2 weeks thereafter. Let the matter appear in the list in the 3rd week of April. Deep children.
ও দিয়ে দিয়েছে, চাইছিলেন না কথা বলে না, চাইছিলেন।
Then 25 it is stated 25.